Welcome to the Ada K Show. I'm your host, Ada K, and I am a criminal justice major. I am also a deaf courtroom commentator, breaking down the gripping courtroom drama while providing full ASL interpretation, making justice accessible to everyone. Grab a cup of Java and let's dive in. Don't forget, comment, like, and subscribe. And if you love this channel, please become a member. Hey! Well, y'all, we are going to be changing a lot of things around here in the near future. And guess what? My camera's too high. There it is. Yay. We're going to be changing some things in January. So that music will go bye-bye. So we only got a few more times to hear the intro. I'm Ada K. Welcome very much to my channel. We were not going to be live today, but then all of a sudden things happened and we didn't know what's going to happen. So we're live. We're live. And it's good to see every single one of you. Thank you so much for joining. And for those of you who have just recently been joining and following, yes, I'm a graduate. I am now a criminal justice, not a major, but I have a criminal justice degree. So I see myself as a criminal justice professional who focuses on disability. And so anyway, that's kind of who I am. Thank you so much for joining. We are going to do two things today. First, we're going to go into the Maya Hernandez case, California versus her. She is the Brazilian butt lift child red rumor. What does that mean? Well, let's just say the woman, it just came out in court. It was a Brazilian butt lift, but it used to be known as the lip filler red rumor because she left her child in the car while she went in and had cosmetic work done. And she, how do I put this? Decided to leave the child or children in the multiple children in the car. She left the air conditioning running, but didn't realize that after a certain period of time, the car would stop all that. And one of the children died and the other one was severely injured. So what I'm going to do is give you a quick case thus far, rundown of this case, and then we're going to get into closing arguments. This is something that was not on my radar, but popped into my radar yesterday, and so I want to kind of go over the case with y'all. This case is California versus Maya, depending on how you pronounce it, Hernandez, involved in is a 20-year-old mother on trial in Kern County, charged with the red room manslaughter and child endangerment after leaving two young children in a car while she underwent cosmetic procedure. Her 1-year-old son, Emilio Gutierrez, tragically died of a heat stroke, while her 2-year-old barely survived. June 29, 2025, Bakersfield, California. This is where the event happened. She is charged with first-degree red room involuntary manslaughter and child endangerment. She, left her children strapped in car seats with food, milk while she went inside the med spa for lip filler injections. Well, that's what the original charges were, but it was then later yesterday or the day before, a witness in trial who worked at the med spa said it was not lip injections, which is a much shorter procedure. It was a Brazilian butt lift, which means she would have been anesthetized. So she claimed that the car was running with the air conditioning on, but her Toyota Corolla hybrid automatically shut off after an hour. Prosecution's argument said that Hernandez knowingly endangered her children, prioritizing cosmetic procedures over their safety. The defense argued that Hernandez testified that she believed that the car AC was on and running and did not intend to harm. As of December 16th of 2025, closing arguments are underway, which is today, and the jury is preparing to deliberate. In the courtroom, the highlights for this case, Hernandez admitted she was aware of the dangers of leaving children in car, having seen news reports, but insisted she thought the AC was on. Prosecutors emphasized her choices of leaving the children for hours while undergoing a cosmetic filler injection. Boo. I've been with someone who got an injection. It was a 30-minute appointment. Walk in, inject, walk out. Well, it was about a 30-minute. Maximum an hour. Butt lift is hours. The liquid butt lift. The pathologist confirmed that Emilio died of hypothermia or hyperthermia, and a body temperature was 107 at the time at the hospital. Hernandez broke down at the stand saying, "I didn't leave him there to die." Well, I never left my kids. Well, when my children were older, yeah, but not that young. When they're able to physically get out of the vehicle, that's one thing. But when you're strapped in a car seat, boo, that's a whole nother ball game. So anyway, that is where we are. We're going to go ahead. We are going to join them at the beginning of the opening statements. Thank you, Court TV, for the feed. We really love and appreciate you. So here we go.
A cosmetic procedure. In her words, a procedure to make her feel more beautiful. That choice, ladies and gentlemen, the choice for her to feel more beautiful, to focus on herself, to focus on her looks, killed Emilio. On that day, she chose the appointment in Bakersfield. She chose to drive from Visalia to Bakersfield with her 2 children. She chose not to get a babysitter, knowing she had options. She chose to bring them to Bakersfield, knowing that she would be permitted to bring the kids into the building and they could wait in the waiting room. But what choice did she make, ladies and gentlemen, when she got to Bakersfield? She chose to leave them in the car. She didn't choose to leave them in the car while she ran inside to get milk. She didn't choose to leave them in the car while she ran to the mailbox. She chose to leave them in the car for 2.5 hours. 2.5 hours where she did not check on them one single time. And ladies and gentlemen, what was happening to Emilio while the defendant was sitting inside the building, while she was chatting with other adults, while she was socializing, while she was in a cool atmosphere? What was happening to Emilio when his mother, the one person who was supposed to protect him, the one person who was supposed to put him above all else, what was happening to Emilio as she sat in the building and ignored her responsibilities? He was burning from the inside out. His body was rising to temperatures that are not compatible with life. You heard that quotation from Dr. Thomas Riley. His body temperatures were not compatible with life. While his mother sat inside, socializing, laughing, chatting, sharing stories about cosmetic procedures, talking about her plans, talking about how hot it was outside. Emilio was perishing in the car while Mateo sat there and watched. Ladies and gentlemen, as adults, we are all entitled to make choices. We get to choose what we do on a daily basis. That's part of being an adult. But the other side to that coin is, as an adult, when you make a choice and that's a bad choice, you have to be held accountable. The defendant in this case on June 29th, 2025, made many, many, many bad choices. All of those choices benefited her at the peril of her children. It is now time for her to be held accountable for those choices. It is time for her to be accountable for leaving her 2 babies in the car, knowing it was dangerous and knowing it was irresponsible. And ladies and gentlemen, you as the jury now get to look at the defendant and tell her that her choices were wrong. That putting her vanity, her looks, her desire to feel beautiful above her children was wrong. Not only was it wrong, but it was criminal. Not only was it wrong and criminal, but she did it knowing it was dangerous, knowing it was wrong, knowing it could harm. And ladies and gentlemen, you are going to convey that message to the defendant. You are going to tell her it's time for her to be held accountable. You're going to tell her what she did was wrong by finding her guilty of the murder of Emilio and the child abuse likely to cause great bodily injury of Mateo. That is the opportunity you are going to get to have at the end of this case. After I speak with you, after Mr. Wakeman speaks with you. But in order for you to make those findings, you need to know the law. You need to know the law and how that law connects with the evidence. So I want to take some time this morning and I want to go through the evidence you have in this case. I'm going to connect that to the law in this case. And at the end of my argument, I will explain to you why the evidence, when mixed with the law, when compared to the law, is going to be sufficient for you to find the defendant guilty beyond a reasonable doubt. And I want to apologize ahead of time. You might have to hear me talking for quite a while this morning. There's going to be a lot I have to say. You might find what I'm saying to be boring at times. You might find what I'm saying or what I'm publishing to you to be redundant at times. And there will be some slides you will see multiple times. But ladies and gentlemen, as you now know, this is an important case. The evidence and the law is important. It is important that when you go into that jury deliberation room, you are fully equipped to make the appropriate decision. And I want to take some time this morning to make sure that you have the tools necessary to make the just verdict in this case. So first you have the information. Count 1, second-degree murder of Emilio. The lesser included, it shows as count 2. It is a lesser included offense. She cannot be found guilty of both. Involuntary manslaughter of Emilio. Count 3, child abuse of Emilio resulting in his death. And count 4, child abuse of Mateo. Second-degree murder of Emilio, count 1. And I'm sure, ladies and gentlemen, you can imagine the bulk of my discussion with you this morning, the bulk of my argument is going to be spent on this very charge. I'm sure you have noticed throughout the evidence that this charge is why we are here today. We are here because Emilio died at the hands of his mother. We are here because she caused his death. She did it with conscious disregard for human life, and she knew the dangers to human life when she acted. The elements. And again, as I described in opening statements, there are 2 different ways in this case, not in every case, but in this case, there are 2 different ways to get to second-degree murder. First, second-degree murder, implied malice theory. Commission of an act. The second way, which I will discuss in a moment, is second-degree murder, failure to act. First way, commission of an act. Second way, failure to act as a mother. Defendant committed an act that caused the death of Emilio. When the defendant acted, she had a state of mind called malice aforethought. Malice aforethought is defined for you in the instructions. In your instruction for this charge, instruction 520, there's going to be one single sentence that tells you what express malice is. That sentence can be ignored. This is not a case of express malice. I am not, and I will not argue to you this morning that the defendant had an intent to kill Emilio. We are here for implied malice. And implied malice means she intentionally committed the act. She intentionally left Emilio in the car. That's the act that satisfies the first element of implied malice. The natural and probable consequences of the act were dangerous to human life in that the act involved a high degree of probability that it would result in death. She left Emilio and Mateo in the car for 2.5 hours in the middle of a Bakersfield summer in extreme heats. At the time she acted, she knew the act was dangerous to human life. Ladies and gentlemen, I submit to you that I anticipate most of what this case and today's arguments are going to rely on falls right here. At the time she acted, she knew the act was dangerous to human life. You know, based upon her interviews with Detective McNabb, based upon her actions, based upon her failures to tell anybody inside of the spa that she had her children with her, that she knew her acts were dangerous, that she knew they were dangerous to human life. She got in here and she testified and she told you a different story. I will spend some time going over which of those statements is going to get you where you need to go. And she deliberately acted with conscious disregard for human life. She knew what she was doing, she knew it was dangerous, and she did it anyway. She knew it was dangerous to leave the babies in the car, but she did it anyway. She did it anyway because that day, June 29th, 2025, was about Maya. It was about Maya's wants, Maya's needs. That day was never about Emilio. It was never about Mateo. And it was never about protecting the boys. Second-degree murder, failure to protect. This one, first element, the defendant had a legal duty to protect Emilio, and the defendant failed to perform that duty, and that failure caused the death of Emilio. You will see in the instruction for this crime that a mother has a legal duty to protect. You don't have to guess on that. You don't have to speculate. That is the law. You know that the defendant in this case is the biological mother of both Emilio and Mateo. You know that it was her duty to protect as the mother, and she failed to do so. She gave you this element when she testified. She said she knows she failed to protect them. She failed to protect them because she should have brought them in with her. She should have left them with a babysitter. She should have done absolutely anything, ladies and gentlemen, other than leaving them in a car to burn and perish. When the defendant failed to act, she had a state of mind called malice aforethought. Implied malice, again, ladies and gentlemen, the same requirements for both ways to get to second-degree murder. The only thing that changes is the act versus the failure to act and the failure to perform her duty as a mother. We often hear the term malice, and in ordinary language, that sounds like a bad word. Like that sounds like we have to have hatred, ill will. No, ladies and gentlemen, not in this courtroom, not in the law. The law will specifically tell you when you're looking at Calcrum 520, malice aforethought does not require hatred or ill will towards the victim. The defendant did not have to be mad at Emilio. The defendant did not have to hate Emilio. It's okay that you saw those photographs of the defendant showing affection and loving Emilio. None of that negates the elements of second-degree murder. Nothing that you saw in those photographs negates implied malice. It's okay that she wasn't upset with Emilio. It's okay that she didn't hate him. It's okay that she did not intentionally kill him. Because none of that is required for second-degree murder, ladies and gentlemen. Now that you know the charges and the law that apply to those charges, how does that intertwine with your duties, with your job as the jury, ladies and gentlemen? It is now your job to decide what happened that day. It is your job to decide what was the defendant thinking that day. What did she know before she got out of the car? It's your job to decide that. And you decide that by taking all of the evidence you have heard, the witness statements, the testimony, the photos, the defendant's recorded interview, text messages to the nurse. You get to take all of that and you decide what happened that day. You decide what was she thinking that day. You apply that to the law. And once you do that, you come to a conclusion. And that is your job, ladies and gentlemen, as the jury. We told you during voir dire that you can't come in with special knowledge. You can't come in with your own medical opinion as to what happened. You can't come in with any preconceived notions about what happened. You can't come in with, oh, the media said this, I'm going to believe A, B, or C. But the one thing we never asked you to leave outside was your common sense. And that's because your common sense is of utmost importance in your deliberations, in your deciding what happened in this case. Do not leave your common sense in this courtroom when you go into the jury deliberation room. Take it with you and use it. How did we get here today, ladies and gentlemen? As I previously described, the defendant made an appointment to drive from Visalia to Bakersfield to receive a cosmetic procedure. Now, when she initially testified on direct, she attempted to make it sound like this was a last-minute sort of thing, that she had to come and there wasn't really much time for planning. But you learned on cross-examination that that was not the case, that she knew about this appointment for at least days ahead of time, and that she had been attempting to schedule this appointment since early May. But more importantly, ladies and gentlemen, you know that this was not a mandatory procedure. This was not a procedure that she needed for her health or well-being. This was an elective cosmetic procedure for the sole purpose of enhancing her looks and helping to make her feel beautiful. So any statements that I didn't have enough time to decide what I was going to do with him or find a babysitter, those go out the window, because this was all based around the choices she made. This was not an emergent situation. It was not a last-minute situation. The defendant made the choice to drive to Bakersfield with the two boys, Emilio and Mateo. She knew before she left home that she could bring the boys inside the spa with her. They would simply have to wait in the waiting room. She knew that she had a stroller in her car that both of the boys could sit in, be strapped in, just like in their car seats, and sit in the spa. She chose none of that, ladies and gentlemen. She arrived in Bakersfield. She chose to go inside at approximately 2:04 p.m. And at that time, she chose to leave her children in the car. She sat inside that business in the same chair from 2:05 to 4:09 p.m. Did not move from the chair, ladies and gentlemen. You watched that. She didn't get up to check on her appointment time. She didn't get up to ask how much longer. She didn't get up to tell anybody she was in a hurry. She didn't get up to check on her kids. At 4:09, she goes back for her procedure. And at 4:33, she leaves the building. Even at this time, ladies and gentlemen, 4:33 p.m., she does not leave to go check on her kids. And you heard that through her interviews with detectives. She left to go get her phone to pay. Even when she left at 4:33, her children were not the priority. She did not leave to go get her children. She left to go get her money. Again, with Maya as the priority, not her children. After a 911 call is made at 4:40 p.m. on that day, officers are dispatched around 4:43 p.m. and arrive approximately 4:45 p.m. at the business that day. By the time officers arrive, this was Officer Velez Aguilar and Officer Fahel. All ambulance personnel are already on scene providing treatment to Emilio. You saw the body-worn camera, ladies and gentlemen. You saw Emilio's lifeless body on the gurney. Emilio was ultimately transported to Adventist Hospital, where he was treated by Nurse Gabrielle Long and Dr. Thomas Riley. You heard from both of those witnesses. You heard that at the scene, officers also observed Mateo. Now, by the time officers saw Mateo, he was soaking wet, he was red. A lot of that water, that soaking wet, did in fact come from efforts of Harmony and Shelby to cool him down, putting water on him, pouring water on him. But you also heard from Shelby and Harmony that before they started putting water on Mateo, he looked like he was about to have a stroke. He was hot to the touch, and he was sweaty. You heard Ian Blue describe Mateo.
I'm going to pause right here. If people don't know anything about heat strokes, as long as he was sweaty, that was a good sign. The moment there's no sweat, very deadly. But the fact that he was sweaty, that saved his life.
He said, it's a term we use in Spanish. It means kind of like wet chicken. The way he looked with his hair wet and stuck to his face when he went into the business. Mateo was also transported to Adventist Health Hospital. Emilio arrived at the hospital at about 5:00 p.m. He was ultimately pronounced deceased at 4:48 or 5:48 p.m. I apologize. You heard from Dr. Riley. They were as aggressive as possible in their attempts to save Emilio. They were as aggressive as possible in resuscitating him. They were as aggressive as possible in attempting to cool his body. They did cool his temperature from about 107 to 101, but that was not sufficient because it was too late. And you heard from Dr. Riley that early intervention could have saved Emilio. The defendant going out to her car to check on Emilio could have and would have saved Emilio. You heard Dr. Riley talk about how heartbreaking it was to see a 12-month-old in the condition Emilio was in. That it was gut-wrenching that he was unable to save Emilio on that day. He even said at one point, physicians are humans too. They don't put on a cloak and not have feelings. And he explained those feelings to you of seeing a 12-month-old boy come in completely lifeless. We'll talk more about his testimony in a few minutes. Mateo was transported to the hospital. While in the hospital, his temperature was approximately 99 degrees. He was fine and he was ultimately released. You heard Nurse Elizabeth Bond explain to you the difference why Mateo was okay, but Emilio wasn't. And it was because of their age. Emilio was not yet able to regulate his inside temperature because of his age. Mateo had more developed sweat glands, which explains the sweat on the outside of his body when he was located. Video surveillance. The detectives had information. The defendant told them, I left him in the car for 2 hours. She was very forthcoming about that from the start, ladies and gentlemen. The detectives could have rested on that and been like, okay, she told us. They wanted to see what happened that day. They wanted to make sure this was a complete and thorough investigation, so they got the video surveillance from the business. In that video surveillance, you can see the defendant walking up to the business at about 2:04 p.m., ultimately takes the seat by not the west door, but the door across, where she sits for the rest of the time until 4:09 p.m.
Y'all, I just realized something. This woman is pregnant. Can you imagine being an assistant DA trying a case like this while you're pregnant? Oh, my emotions would have been everywhere, y'all. Oh my gosh, she's making some really good points. I'm really appreciating her closing arguments right now. She's nailing it. But boo, my heart goes out to you, dude. I wouldn't want to be doing this pregnant.
At 4:09 p.m., you see the defendant get up and walk in the area that we have been told is the area of the rooms for service, room B6. You also saw that and can see that on the body-worn camera footage of Detective Barthelm's conducting the measurements into the building. The defendant ultimately leaves the building for the first time at 4:33 p.m. You heard about the search of the defendant's vehicle. The infotainment screen was broken. They were not able to get any immediate information from the infotainment system about what specifically was happening in that car. There was a bottle found behind the passenger seat, right by where Emilio's seat was. And ladies and gentlemen, this might seem very minor, but it's not. You heard that the bottle found by Emilio's seat was 2/3 full. You also know that Emilio was strapped into his car seat. He could not get out. If he dropped that bottle while he was still okay, he had no liquids to drink. If he dropped that bottle after he had began to perish, he began to perish pretty quickly before he could even get halfway through his bottle. Neither of those scenarios is beneficial to Emilio. Both of those scenarios tell you that had the defendant gone out to check on them, she could have fixed the situation. You also heard that the defendant had a stroller in the trunk of her car. This also might have seemed like a fairly insignificant find when you heard the evidence. But you now know that it was not insignificant, ladies and gentlemen. This piece of evidence is not insignificant. This piece of evidence tells you that the defendant had the means to bring the kids inside with her. She had the means to literally put them the same way they were in the car. Sit each of them in their seat, strap them with the harnesses that you saw in Defense Exhibit 10, hand them the phone, and let them watch TV. Same exact condition they were left in the car. But in the stroller, they would have been inside, out of the elements, not subject to the heat, and we wouldn't be here today. But Emilio would. But the defendant chose not to use the stroller because that would have meant that she had to watch them and control them while inside the business, and that is not what she wanted to do on that day. You heard from witness Shelby Murch that she was a patron that day at the med spa. She was also waiting for her procedure. She was there approximately 30 minutes before the defendant arrived. She told you and she described for you the atmosphere in the waiting room. And you ultimately got to see the atmosphere, ladies and gentlemen, but Ms. Murch described it for you before you saw the video surveillance. And what you saw in that video surveillance perfectly matched what Ms. Murch told you. It was a friendly, welcoming, lively atmosphere. People were chatting, they were talking. There was another child. While the defendant was in the waiting room, she was bubbly and engaging in conversations with the other patrons. Bubbly and engaging in conversations with the other patrons, she told them.
Okay, guys, we got some breaking news. And you know what I'm going to do? We're going to listen to the rest of this during breaks. But y'all. We have some breaking news. I'm pulling it up. Give me a second. Attention, ladies and gentlemen. Nick Reiner. Alan Jackson's in my corner. Oh, Lord. Nick Reiner is calling in heavies after being arrested for allegedly red rooming his famous parents because Alan Jackson tells us Nick hired him as his defense attorney. Alan is one of the most well-known criminal defense attorneys out there, and he is no stranger to the high-profile cases like this one. He recently got Karen Reed acquitted of red room in Massachusetts. As you know, Nick was booked for red room charges of Rob and Michelle Reiner were found dead Sunday in the Brentwood home, and he is being held without bail. They started him at a $4 million bail, and they revoked the bail. We saw Alan heading into the Los Angeles courthouse Tuesday for some legal proceedings related to Nick's case. So the game is on. TMZ broke the story. Nick got into a heated argument with Rob and Conan O'Brien Christmas party Saturday night. Loud enough for others to overhear. Rob and Michelle left the party after the fight. About 4 a.m. Sunday morning, Nick checked into Santa Monica Hotel and left a trail of blood behind him. Sources will direct knowledge told TMZ. Nick has been open about struggles with the substance abuse, cycling through rehab centers and being homeless at some point. And will be interesting to see what kind of defense his parents defense that he has concerning his parents. Stay tuned. So, Alan Jackson has been retained as the attorney for Nick Reiner. Go figure. Here we go. That is one that we are definitely going to be following. Hello, Spin Steer. AJ represents shady people like Weinstein. Oh, okay. But we also need to get back into the Ian Mitcham trial, and they have the next witness on the stand. We will continue watching these closing arguments during the break periods in this trial. Excuse me, I had to take a sip. I am recovering from COVID and a lot of stuff going on. Thank you so much for your thoughts and prayers. But if I'm drinking a lot, eating a lot, and coughing a lot, it's to keep that saliva going because it's a nasty cough. All right, guys, thank you so much for everybody joining us today. Please don't forget that if you want to join us in Discord, there is our thing. Scan it, join us in Discord, validate your account. We have some fun things over there, and we do a lot of movies and a lot of sporting events together. We will be doing Super Bowl together, y'all. Big time. We will be Super Bowl partying, playoff parties. We'll be watching playoffs for those who like football. But anyway, it is a fun time over there. And Miss June is our sports person. I always have her stream it because she has all the sports stuff. So please come join us. Don't forget to subscribe. I'm sorry, I'm leveling up our next video. Don't forget to subscribe. We greatly appreciate you guys, and show us some love. We need some love. We appreciate the love. So give us some love, y'all, when you can. Also, don't forget the holidays are coming up. Make sure that you stop off at our merch shop. I've got some cute stuff over there. I'm working on a whole new line for next year. A whole new line. Instead of a whole new world. I got that in someone's head yesterday. All right, let's pop in over here. Let me embiggen. Let me get everything up and going. Nope, that's what we want. Okay, let me stop the banner. Okay, let's get rolling.
And you have a microphone right there. I'll just ask that you pull it close to you and speak loudly and clearly. Thank you.
Morning.
Good morning.
Can you hear me okay?
Yes.
Could you introduce yourself to the jury, please?
My name is Elisa Smaltz.
Can you spell your last name again?
Smaltz.
Are you currently employed?
I am a part-time contractor for the city of Peoria.
Okay, what are you doing for them?
They needed assistance.
Okay, guys, I cannot fix the audio. They are in a monotone mic, not a stereo mic. So if you're hearing this only in one ear, that is on their end. I cannot make it stereo from this end. But that said, at least he's got the mic in his face, but it is horrible quality. I will be making some adjustments. So if you are hearing some adjustments going on the microphone, don't panic. It's me trying to make it better, but there will come a point where that won't happen. They have such horrible audio. I don't understand in this day and age why we have such horrible audio. Here we go.
With verifications of their technical casework and latent prints. So that's what I did.
Prior to that, were you employed by the City of Scottsdale Crime Laboratory?
Yes, I was.
And when did you go to work there?
I started there in 2006 and worked there until the end of the last day of last year when I retired.
All righty. Can you give us a little synopsis of, well, first of all, let me ask you this. Over the course of your career at the Scottsdale Crime Laboratory, tell us a little bit about what you did, starting from the beginning up until your retirement.
Well, I was first hired as a latent print examiner in their latent print unit. The latent print unit soon thereafter was put in with the crime laboratory, so our titles changed to forensic scientists. And I worked my way up through the ranks, becoming a forensic scientist supervisor, and then after that being promoted to the forensic laboratory manager.
Okay. And as the manager, what did you do?
I oversaw all the disciplines in the Scottsdale laboratory.
And when did you become the manager?
In 2018.
Tell us about your education, training that allowed you to do the jobs that you have done.
I started working as a crime lab analyst for the Maricopa County Sheriff's Office in 1992. I worked there until I went to Scottsdale in 2006. While I was at the Maricopa County Sheriff's Office, I processed crime scenes. I did latent print comparisons. I processed evidence from those crime scenes in the laboratory. I did APHIS entries and comparisons. And back then we developed our own film.
Okay. Things have changed.
Yes, much so. And then after that, like I said, I went to the Scottsdale laboratory and I did latent print comparisons. At the Scottsdale laboratory, the latent print examiners do not respond to the scene unless they need specialized assistance. So my primary function at the laboratory as a latent print examiner was we processed evidence in the laboratory and we compared those prints to known subjects.
You, before I forget about it, you mentioned a term, APHIS,
Yes.
AFIS, I believe.
Yes.
Can you explain to the jury what that is?
It's a database. APHIS stands for Automated Fingerprint Identification System, and it's a database that houses many known exemplars from people who either have been arrested, who are trying to obtain a license for various reasons, whether it be like real estate license, teachers, that sort of thing, and then also applicants for government work. They're all housed in that database. And what that does is if there is a latent print out at the scene or that we develop in the laboratory and we do not have a subject, or the subject that they gave us when we compared it to them, if we determine it wasn't that person, we can still try to identify it by placing it into that system to search against all those known exemplars in the database.
You mentioned a moment ago that ordinarily, unless requested, latent print examiners, at least at the Scottsdale Crime Laboratory, would not respond to a crime scene, correct?
That's correct.
So was much of your work as a latent print examiner done actually in the laboratory itself?
Yes.
Maybe get some of that water that is up here. Thank you. I don't know if this applies to everyone here, but I would think that at least it's possible that when someone mentions the term latent print, they're thinking of fingerprints, which would be the case. But also sometimes do we leave prints on surfaces from other parts of our body?
Yes, there's friction ridge skin is what makes up a fingerprint or a friction ridge print. You have them on your hands and on the bottom of your feet.
And is it just the tips of the fingers or other areas of the hand?
No, it's the entire hand, your surface here. Fingers, the fingertips, the length of your fingers, and the palm.
Thank you. And so if I walk across a surface barefoot, I might leave ridge detail.
That's correct.
And I think I had Ms. Metz explain friction ridge detail yesterday, but let me go ahead and ask you to do the same.
Friction ridge skin, everyone has it. If you look at your hands, you have like ridges and furrows. Biologically, it's there so to assist someone in gripping, and there have different breaks and minutia in there that identifies that print to you uniquely.
Assume for me that we've had a description of the process of on occasion lifting a latent print that has been found on an item. That lift is taken to the crime laboratory where you worked, and you were asked to compare that lift to known print impressions. Okay?
Yes.
So you mentioned that, for example, someone might apply to become a teacher or other government position. And in order to get licensed, they have to submit prints. And those prints, images of those prints at least, are put into the APHIS system, correct?
That's correct.
Maybe someone on the jury has never been fingerprinted, but let me have you describe, for example, if I had to come to the crime laboratory because I wanted to become a teacher, I was required to have my known prints taken. How would that happen? How would you accomplish that task?
You would go to a designated location in which they offer that service. For instance, for a license, as you described, most likely you would be printed using black printer's ink and a paper stock card that has a place for all 10 fingers rolled and placed directly straight onto the card. But if you were, for instance, being arrested, most likely it's now live scan. It's done digitally. It's a piece of glass on a station in which they roll those prints and they go directly into the database.
Digitally?
Digitally, yes.
Okay. when you're in the laboratory and you're asked to do a comparison between a latent from a scene, latent lift from a scene, um, to known prints, how do you go about doing that?
The first thing I do is I check to see if they have any fingerprint record on file. If they do, most likely I can retrieve those digitally. Sometimes agencies have files that are the way that I described before, using black printer's ink. So I would do my best to try to locate the unknown fingerprint record for that person.
And then how do you go about determining if those match or not?
I first, with the latent print, the first thing I'm going to do is I'm going to look at it to see what kind of detail is there. Is there even enough there for me to conduct a comparison? The next thing I'm going to look at is to see anything like if there's distortion in that print, so that I can take that into account when I'm doing the comparison. So I analyze that print and I notate, mentally the uniqueness of that print. And then I take the 10 print record that I have on the subject that is to be compared, and I start looking for the target group that I've memorized in my head. Like, I look at the print, I pick out a certain area of the latent print with the detail, and I'm trying to locate that in the area, the 10 print card or the palm, depending on if it's a 10 print or a palm. And if I see an area in the exemplars that looks similar, then I go and take a deeper dive look into that print, and I start comparing the minutia to see if they're in the same relative position in the same area of that print, until I'm satisfied that either it is that person or if that person can be excluded.
Now, you told me, if I understood you correctly, that on occasion you might be called to crime scenes, correct?
That's correct.
In fact, when you were with the sheriff's office, that's what you did, right?
Yes.
So imagine you're at a crime scene and you're looking at an item, a tabletop, for example, and you are your task is to see if there are any fingerprints, palm prints, footprints, whatever on that surface. Is the only way that you can preserve what you find by that latent lift process, or do sometimes you photograph the
Yeah. Yes. Okay. So when I'm going to process an area, the first thing I determine is, what is the surface I'm processing? What kind of surface is it? Is it porous? Is it non-porous? Is it textured? Is it wood? Is it glass? That sort of thing. And then that will allow me to determine which process is best to use on that surface. So
Okay, I gotta do a pause here. I'm going to do some commentating for a change. Learned a lot about fingerprints. I've learned a lot about things through my degree as a criminal justice major and working with other people. I wanted to give you all a little bit of heads up. I'm not finding that she's really explaining this very well, so let's see if I can help with that. Fingerprints remain stable throughout a person's lifetime. So our fingerprints that are taken today can be matched against ones taken 15 years ago with very high reliability. We might have some cuts and things that may happen, or injuries that may happen over the years that might slightly alter them. But overall, in general, oh yeah, we got a Ian Mitcham bingo card. Let me go get that in a minute. Oh, for tomorrow. Okay. Rabbit trail. So anyway, we have all seen on CSI shows and on TV where they do the fingerprints and they match them and they put them in a database and it's a brrrr, and you see these little, and then sometimes when you see it, they'll have like 15 or 20 red squares with little dots in them and they're matching them up and all that. That is true, but it doesn't work that fastly. It is slightly altered. So the modern automated fingerprint identification system, which is the AFIS, which is what I was just describing, actively and achieves accuracy rate of 95 to 99% when prints are clear. Now, that said, these are perfect, ideal prints. It's not like a print of somebody's hand on the wall that was covered in blood and then on a wall, which the wall is textured. The blood creates textures and crevices, and it alters the prints enough to where sometimes that is not something the AFIS can be utilized. So latent prints, or which considered a partial or smudge prints, are more difficult. Those error rates range from 0.1% to 1%, depending on the quality of the examiner's skills, because those are done by the naked eye. Why fingerprints work over time. So fingerprint ridges and patterns do not change with age except for superficial damage, like I said a minute ago, cuts and scars. Studies confirm that prints taken decades apart remain consistent. So the defense is going to possibly argue that, hey, these were taken so long ago. How do you know that they're my clients? He's cut his hand and done all that. So that is going to be debunked. No two individuals, no two people share the same fingerprint patterns ever. Even identical twins do not share the same fingerprint patterns. You might share the same DNA, but you ain't sharing the same fingerprint patterns. Environmental factors such as dust, oils, and got to turn on my heating pad. Dust, oils, surface types, etc., can and does often affect the latent print quality, but not the underlying ridge structure. So I want to talk about the old way of reading prints versus the new way, because we have a section of years between this particular red room and coming to trial. So new clear prints, rolled prints, like when you get arrested or when you go to get your fingerprints taken for licensures and such, versus 15 years ago, 95 to 99% AFIS system and human examiners can reliably match fingerprints. Now, the latent prints are partial or smudged or degraded. So when you hear a CSI person talk about latent prints, that means it's not a full print. It's not what I call a full sample. It's either partial, smudged, or degraded. 70-90 to print, depending on how heavy the print is and the clarity, the type of surface, whether or not how it was preserved, whether it's good quality or poor quality or damaged prints. The error rates will rise when the ridge detail is missing or distorted. False positives are 0.01 to 0.1 to 1% rare, but possible if prints are partial or similar in the ridge flow. So what that means is that you see your fingerprints, and some of us have these ridges that come up, they kind of come up like this and they come down and then they get, As long as those ridge patterns are connected and smooth, not broken due to debris or texture of the surface or whatever, as long as that ridge pattern is intact for the most part, then you have a high success rate of matching. With smudges and partial impressions or environmental degradation or residue, it will reduce the accuracy. Now, the modern AFIS database and algorithms outperform older manual methods. The examiner, the human expertise is still critical, especially for the borderline or degraded prints. So, meaning right now the AFIS is very good. Did I say it right? Yeah, AFIS is very good at filling in the gaps and kind of matching things, but the human eye is sometimes more valuable in deciding whether or not these two are of the same or different prints. It's still, both of them still have their very minuscule part of error. The 15-year gap itself, or here, I think it's between 11 and 15 years, itself does not reduce the accuracy. Print remains unchanged, but how they stored it, the quality of the print does matter. Courts generally considered fingerprints evidence highly reliable. Highly reliable. However, latent print comparisons can be complex and error prone when the prints are poor quality. Advanced in digital technology has been made. The machines are learning that the machines that we currently have are learning to reduce the false matches in comparison or in the older system. AI is really starting to come up there, y'all. The fingerprints taken today can be matched against ones from 15 years ago, 50 years ago, 100 years ago, with near perfect reliability if both are clear, if both sets of the prints that are being matched are clear. Now, as the latent or degraded prints reduce the success rate, but modern forensic technology still yields an intense match in most cases. So understand that she's not explaining it all that well, in my humble opinion. So I just wanted to come in and pop in and share that with y'all. Thank you so much for your comments. I'm going to pop them up like that for the moment. Thank you so much for everything that you do as far as supporting this channel. Back, oh, I'm going to take them off. I can't read them. Back to trial.
There's physical processes such as the black powder method lifting, and then there's chemical processes as well. So, for instance, if there's a surface that's more textured, or a print may be in something other than like normal sweat or perspiration, then I'll pick a chemical process, which there's various ones. There's some that's specifically for blood, and there's some that all I'm trying to do is preserve any print that may be on that surface. And for instance, super glue method, it's cyanacrylate, and what happens in that process is that area is, the super glue is fumed. Those fumes are allowed to deposit on the surface, which then hardens those prints and preserves those prints. And then subsequent chemical process like liquid chemicals can then be applied without washing them away. And then those will be looked at like under a forensic light source to be able to visualize, and then you would photograph those.
Would it be possible for you to preserve a latent print that you find at a scene, get it back to the laboratory, and in looking at it, then determine there really isn't, it's a print, but there isn't sufficient ridge detail to do any sort of comparison?
Absolutely. Because typically when you're at the scene, you're just trying to collect as much as you can. It's really not the time for you to do any specific analysis on those prints.
All right, I want to take you back to February of 2015. On February the 19th of 2015, what was your assignment in the laboratory?
I was a forensic scientist supervisor at that time.
And I neglected to ask, when you do your work, either going to a scene, processing an item within the laboratory, what sort of records do you keep of your work?
Anytime a request is submitted and I do any type of examination, then I author an examination report. And during that examination, I also take notes. So the documentation would be my notes plus the report.
And when you, for example, if you responded to a scene and you collected latent prints that could potentially be compared, are those what you lifted or collected from the scene, are those maintained in the crime laboratory? And what I'm getting at here is, for example, a latent print card, which Ms. Metz explained yesterday. Are those preserved within the laboratory?
Yes.
If you take a photograph of, you develop a latent at the scene and you take a photograph of it, are those preserved in the laboratory?
Yes.
I want to take you to February the 19th, 2015. Did you respond to a scene at 8526 East Monterey Way within the city of Scottsdale?
Yes.
Now, why did you go to this scene?
I was requested to respond to the scene to see if there was any assistance I could provide regarding footwear and friction ridge detail that perhaps could use additional processes that the crime scene specialists could not do.
Now, I'm going to ask you, ma'am, this morning to go through a number of reports that I believe you authored. And for your assistance, Exhibit 33, which is a large binder, is there. If you need the opportunity to review one of your reports to refresh your recollection about what you did, let us know, and that can take place. But before I do that, so do you remember going to this scene?
Yes.
And when you arrived, tell us what you did. I mean, initially, what you did.
The first thing I did was spoke to detective there to see where I could enter the residence. Once I was able to enter the residence, I was able to, they showed me around to see the things they had in mind for me. And I offered my opinion on how I could help them.
Okay.
And so after that, after I obtained that information, then I was able to determine what supplies I would need.
And when you enter when you enter into this scene, are you wearing any protective clothing of any sort?
Yes.
And what would that be?
We wear something called Tyvek suits. It's a special suit. They're usually white. And so I would have the booties, a full suit, a bonnet on to cover my head, my hair, and a mask
What
and
about-
gloves.
And gloves, all righty.
Mhm.
I know it's been 10 years ago or so, actually a little longer than that now, maybe, but um, what do you remember, if anything, about what you saw or smelled when you entered the residence?
I entered the residence through the side, which entered like a little, I don't know if it was a pantry area or a storage area that then led into the kitchen. So that's the route I entered. I did not enter through the front door. The first thing that caught my eye was the amount of blood that was on the kitchen floor and a like white, appeared to be liquid at some point, residue on the floor in the living room, and a strong odor of, the only way I could describe it is like bleach or chlorine or something like that.
Okay. The so you mentioned a moment ago that you spoke with a detective, you entered the residence, observed the scene, and then you suggested to the detectives what you might be able to do, correct?
Correct.
And so what was it that you determined that you thought would be the the best utilization of your skills?
That I would look for any footwear or friction ridge evidence within the blood that was on the kitchen floor and on the floor of the living room.
So what, if anything, in terms of footprints, foot impressions, ridge detail on the floor, did could you see any, first of all, just visually?
In the living room, once I actually got down there with the flashlight, yes, I could see that there was some ridge detail, but I wanted to enhance it so that I could see it better. That was in the living room. And in the kitchen, I believe I saw some impressions using a flashlight and some just within the blood that I wanted to enhance.
How did you go about enhancing what you observed?
I did both physical and chemical processes. So I did black powder. Well, first of all, I photographed what I could see first. Then I tried black powder and I tried a chemical that reacts to blood.
Now, after you said you took photographs, would those photographs have been retained?
Yes, I personally did not take those photographs. The crime scene specialist took the photographs at my direction.
All righty. And then after utilizing the chemical processing, might that allow for a photograph to be taken to make it the image itself, the ridge detail, more apparent or obvious?
Yes.
And when we look at a photograph of an area of, let's say, the living room floor, and after the chemical processing, we have some images I'll show you, not right this moment, but they have a distinctive color. Why is that?
That is from the chemical that I used. For example, the ones in blood would be blue after I apply the chemical that I use for that. The ones that aren't in blood, you'll see it has a yellow hue because that dye stain is yellow. And when I use the alternate light source to visualize that, you'll see the image, the ridge detail in yellow, like fluoresce.
Earlier this morning, you explained the glue process.
Yes.
So what was that term again?
Cyanacrylate.
Yeah, all righty. Can you spell that? It's okay if you can't.
Cyanocralate.
Thank you. I thought that might help the court reporter. That's why I asked. So did you do that within the home that day?
Not that day.
Okay. When did you do it, if you did?
The second day I responded.
All right. So how did you go about doing that?
For the area in the living room, because the area was so large, for instance, in the laboratory, when we typically do super glue fuming, we have a chamber that does that. So at a scene, which the floor was much larger, I had to create a portable tent. So what I did was I took traffic cones and I placed them around the area of the floor that I wanted to process. And I placed plastic across those cones to create a tent. And then I proceeded to do the super glue process, which involved, I had a portable heater, a hot plate, in which I applied super glue into a tin dish and placed that on the hot plate. And I heated that up within that sealed tent that I made. And I also put a humidifier in there because the super glue needs humidity in order for it to adhere to the surface. So I humidified the area, then put the glue in there to heat it up so that it would fume. And I let that fume for a while and then took it out. And then I had to then clear the house and for it to air out.
the chemical.
Yes, the chemical needed to air out.
And then were photographs taken of any ridge detail that you observed?
Yes.
Um, did you find, or did you observe, do you recall observing any apparent sock prints in the kitchen?
Yes.
Um, did they appear to be within the blood?
Yes.
And when you described them as apparent sock prints, what was it that you saw that made you believe that?
It was, I observed like an outline of a foot because I could clearly see like the outline of what appeared to be toes and then the rest of the foot. And there were linear lines, a linear pattern within that impression. And they were all parallel. The lines were parallel along from the what would be the heel to the toe, and they were just in rows, which friction ridge is not like that.
And when you were observing this, I mean, you mentioned there was blood on the floor, but were you able to determine if the sock print was there first or the blood was there first? Was that possible?
It appeared to me that the sock was there after the blood.
Did you also observe what you believed would be shoe prints on the tile floor in the kitchen?
Yes.
And did you process those and cause them to be photographed?
Yes. Those were photographed and lifted with a gel lift.
Okay, explain that process for us.
So we did various processes. Like I said, I tried to powder it. I applied chemicals, and I also lifted the impression with a gel lift. A gel lift is merely similar. It's similar to a latent print card, like a paper. So we laid out.
There we go. Oh, I still the phone thing up. My bad. Y'all, we got to take it down.
In the location of
Not on the phone.
imprint or ridge detailed area so that those could be photographed.
Okay, ma'am, I'm going to show you a few photographs that have previously been admitted into evidence. And the first one I'm going to show you is Exhibit 514. Can you explain to us what we are seeing here?
In this image, you can see the traffic cones that I described to you earlier, which assisted me in creating a tent. And there is the placard L5 displayed there. And you can also, in that image, you can see the hot plate that I was describing to you with the tin, with the super glue. You can see that the super glue has changed color because it was heated.
So this object that I'm pointing to on
Yes.
a cone?
Yes,
And so this particular photograph, then it sounds like would have been taken after you had utilized the super glue.
yes.
And in the chair back here, this plastic sheet, you know what that is?
It looks like plastic, but I don't recall if that was the plastic that I used. It could have been, but I don't recall.
All righty. In order to process this area, did you have to cause the couch to be moved?
Yes, so that we could get in there to move around and be able to build the tent.
Showing you exhibit 306. Describe for the jury, please, what we're seeing here.
Those are areas of interest that we labeled that were going to be photographed. You can see all the little paper placards there with the cones again that I described were used to build the tent. Right here towards the front of the photograph is the forensic light source that was used after I applied the liquid chemical onto the surface after the super glue. And
What is this apparatus?
that is the forensic light source.
Okay.
And towards the top of the photograph, up against the chair, is broken down pizza boxes. Again, like I said, I was trying to do things that are typically in the laboratory out at a scene. So in order for me to visualize those prints with the forensic light source, I needed that area to be completely dark. And as you can see, that big window there, it was producing too much light. So I literally was trying to cover that area with the extended out pizza box to not allow the light in, and so that I could use that light source to look at what was produced after I super glued it and applied the chemicals.
Showing you exhibit 307. This particular area of the, well, first of all, does this appear to be that living room floor?
Yes.
This surface as one looks at it, might think it was wood, but was it wood?
No, it was the hard tile that's made to look like wood planks.
There's an area here in the middle of the photograph. I'm not sure how to describe the color, but it's clearly different than the other parts of the floor. What can you tell us about that?
That was the chemical that I spoke to you about previously. It's a yellow colored dye stain, which was applied and will adhere to the friction ridge that has been preserved with this super glue process.
Showing you Exhibit 304, which is in evidence. I see a placard that is L5A. What information does that provide us?
There's friction ridge detail in that print. You can see that it's the yellow is, the friction ridge detail is brighter than the yellow background.
Yeah. For those who aren't seeing what you're describing, trying to get it, it's hard to get it on the screen. So you see the ruler, it looks like.
Yes, and probably from the jury's vantage point, it just looks like linear ridges that's to the right of that scale.
Here.
Yes. Yes.
What did it appear to be at the time that you were looking at it?
It appeared at the scene, like I say, I don't try to particularly analyze it, but it was a larger area, so I assumed it had to be a palm or a foot.
And Exhibit 305. Now here, for the purposes of the record, I'll just say it looks yellow to me. The other 304 appeared to be orange or red. Why is there a difference in the colors?
It's just the lighting and the exposure that the crime scene person had their camera on. I know that they were taking a lot of pictures at different exposures so that they could actually capture the detail.
See the arrow in the ruler? Here.
Yes,
What's the purpose of that?
I don't recall.
Okay.
What? Whoa. Whoa, guys, I'm actually working on a resume. There's a job. It's an insurance fraud investigator that I'm applying for. I know, right? You don't remember what this is for? You need to know everything inside and out about your part of the case. How in the hell can you tell me that you don't know what this is for?
Do you see the date? Oh.
I know it is dry as the Sahara Desert. I can't do anything about it. I'm going to speed it up though.
Yes,
I can do that.
It'll be February 20th. Would you agree?
yes.
and then labeled as 5A.
Yes.
The color of that is
Over
changing.
35,
The color is changing. Doesn't matter. The fact is, you can see the smear. You can see there is something there, but she should have more information
Where?
she's giving.
Were you seeing ridge detail?
To the way I'm looking at it on the screen, to the left? To the left of
Here?
the scale, yes.
Okay.
That arrow in the scale was probably a directional arrow. But I don't know what the crime scene people, what direction it was pointing. Usually it's north.
Showing you Exhibit 85, which is in evidence. What area of the home appears to be the focus of this image?
Everything.
And you can see in the back of that in the mirror how we were dressed. You can see the reflection.
Here.
Yes,
Alrighty. And so that white appearing item is a Tyvek.
the Tyvek. Mhm.
And we see an L1 and an L2. Would you agree?
Yes.
So I have Exhibit 86, which has the label a little difficult to see. Part of it's cut off. Appears to be L2. Would you agree?
Yes.
And above the yellow placard, are we seeing an impression?
Yes.
And at the scene, were you able to, did you develop any kind of impression of what you were seeing as to what, I use the word impression twice, but image you were seeing?
Yes.
And what was that?
We photographed it. It appeared to be a partial shoe print. With just this image, can I refer to my notes if it was a partial or full impression?
Yes, ma'am. You could look. There's a, I believe the basis numbers for the 19th and 20th of February begins at 006230.
Okay, so my notes say that it was appeared to be a right shoe with the diamond pattern in the heel and a hexagon triangle pattern in the toe. So for this image that you're showing, we were having difficulty capturing the entire shoe in one image. We had to light it various ways. So I'm assuming there's another photo out there that shows the rest of the shoe, but it may not have been captured all in the same photograph.
Now, directing your attention to Exhibit 85 again, on the floor, I see what appears to be a blue stain. What would that be?
That is the Kamasi blue chemical that I was referring to that reacts to the protein in blood.
In this image, can you see what appears to be some sort of pattern, wavy pattern leading to the hallway?
Yes,
And did you observe it that day?
yes.
Do you recall if we were to imagine a photograph which showed the hallway, this area of the living room, and then the Arcadia door off here to the right. Did that pattern go all the way to the Arcadia door or into the kitchen?
Yes, I believe it started, I don't know exactly where it started, but it was from at the Arcadia door, kind of like in a wave pattern there, through the archway, and then down the hall.
Maybe this might help you. Showing you Exhibit 91. So we see, would you agree with me in this photograph, we see an L3 and an L4
Yes,
and a large mirror, correct?
yes.
Next to the Arcadia door. And this red appearing stain that I'm putting my finger around, this wavy pattern, what did that appear to be to you?
Apparent blood.
And the chemical reactions that you've described, we see at L3 and L4. What did that reaction indicate to you?
That it was reacting with the protein in the blood. So those blue over there by in front of the mirror, there was blood there over there as well.
And showing you Exhibit 89, would you agree with me that this appears to be a close-up of that L4 image?
Yes.
And what, if anything, well, first of all, this particular chemical process was to determine if it was blood?
No, it wasn't to determine if it was blood. It was just that it reacts with protein in blood.
Okay. And what were you attempting to do with the chemical process?
I was attempting to enhance what I saw in the blood.
And
So you can see here, I only applied that chemical. You can see the line of the tile where the blue is up in the top corner. So down at the bottom corner of the image, I did not apply the chemical to those tiles.
within this blue stain, as we're looking at it here, inside the ruler, the
Yes.
L-shaped ruler, are we seeing any sort of ridge detail?
Not ridge detail, that's the detail where not friction ridge detail. There's ridge detail, but I believe the ridge detail appeared to be perhaps from fabric because it was so linear, like the fabric of a sock would be. And you can see what appears to be outlines of toes there.
Same question with, again, in Exhibit 91, we see an L3. Would you agree?
Yes,
Exhibit 87 appears to be a close-up of L3. Would you agree?
yes.
What are we seeing here?
You can see what appears to be the shape of a foot with outline of toes within that apparent blood smear. And you can also see those linear ridge pattern that appear to go like from the toe area down towards the heel area.
I'd like to go through the L numbers. They appear to be, according to your report, L1 through L18. Would you agree?
Yes.
So if you could and again, if you need to review your report, can you tell us what L1 appeared to be?
L1 was a shoe impression in the kitchen that had a diamond pattern on one end and a hexagon triangle type pattern on the other end. L2 also was a shoe impression, what we believe to be the right shoe with a diamond pattern in the heel and a hexagon triangle pattern in the toe.
And were these, did you do a gel lift for these?
Yes,
And were they assigned an item number?
yes,
What was that number?
1020197.
L3, what did L3 appear to be?
That was what appeared to be a full left foot with the vertical linear pattern throughout it, in which I described it was an apparent sock print in the kitchen.
L5.
L5 was down in the sunken living room, and that was friction ridge detail.
L6, I failed to ask you about that, but did you find some apparent hairs?
Yeah, while I was examining the floor, I did find some apparent hairs, so we collected that as well, and that was L6.
L7, 8, and 9. Was that friction ridge detail?
Yes, that was all friction ridge detail down in the sunken living room.
L10, was that a partial shoe impression?
Yes, it was a partial shoe impression with a lug pattern.
11, 12, and 13, were those?
Those were similar to the sock print that I observed and developed in the kitchen in the blood, and those sock prints appeared also to be in blood.
L14.
Was a partial shoe print with a diamond pattern.
L15 and L16.
That was more what appeared to be sock prints in blood.
L17 and 18.
Those were friction ridge detail.
I want to take you now to March 5th of 2015. At least a report dated March 5th, 2015. Did you have occasion while in the laboratory to examine the piece of a broken bottle?
Yes,
And were you examining it for the presence of potential latent prints?
yes,
I have a photograph I will show you a little later, but what do you remember? Well, first of all, would you have, when you examine an item like this in the laboratory, you take notes of the item describing what it is you're going to examine?
yes.
And so when you received this item, describe what it was that you received.
May I refer to my notes?
Yes, ma'am. This would be the report. The Bates stamp numbers begin at 006185.
Okay, my notes state that I received a broken bottleneck that was packaged in a cardboard box. And the cardboard box contained the bottleneck in a glass jar filled with Kim wipes, So you have a jar. There were, the broken bottleneck was wrapped in Kim wipes. Kim wipes are almost like tissue, except a different, it's similar material, but not quite like tissue that laboratories use to wipe down lenses or glass for cleaning. So that bottleneck was placed in the Kim wipes in the jar, assuming so that it wouldn't break. And then that jar was put into a cardboard box with peanuts, the packing peanuts. And that's what I received.
And what, if any, kind of analysis did you do with this broken bottle?
So I processed that item. I was attempting to determine if there was any friction ridge detail on there. So the first thing I do is I do a visual examination. During my visual examination, I did not see any ridge detail. Therefore, I continued with the super glue process that I described to you earlier. Of course, but this is now in the laboratory in a more proper environment for the super gluing. And I placed that into the super glue chamber and fumed that item. I then looked at to see if anything was developed from after the super glue process. I still did not see any friction ridge detail. So then I applied the liquid fluorescent dye, the same one that I used at the scene, called MBD, which fluoresces yellow. So then I looked at that under an alternate light source, which is also the forensic light source that I showed in the photograph earlier. And I still did not see any ridge detail.
Now, while conducting your analysis, did you have in mind the potential that this item might be processed later for DNA?
Yes, and anytime I believe that an item is going to need to be processed for DNA, I always use clean techniques, which means I'm wearing gloves, I'm wearing a mask, I'm cleaning everything prior to and in between each step. I'm cleaning my gloves, changing my gloves, cleaning the utensils that I use, et cetera, et cetera.
And did you do that in this case?
Yes.
And I want to take you to October 5th of 20. Actually, September 20th of 2016 is the report. But on March the 19th of 2015, did you at the laboratory, did you obtain print exemplars for Alex? And I'm going to mispronounce his name. I'm going to spell his last name, Sukhodolov.
Yes.
And did you get finger, palm, and foot exemplars?
Yes, I did.
And the term exemplar, I guess, is probably obvious, but I mean, what is an exemplar?
It's merely the capturing of the friction ridge detail on the hands and the feet, the palmar surface of the hands and the soles of the feet.
I want to take you to a report dated, I believe, September 29th of 2016. And let me ask you to look at 006163, the Bates numbers, please.
Can you say the number again, please?
Sure, 006163. So does this, were you recording your examination of a closet door that had been impounded?
Yes.
And can you tell me, because I'm a little confused by the dates, but what date would this have been done?
I began processing this item on February 24th, 2015.
And describe, Your Honor, it's 5 minutes to 12. It's going to take me a few minutes with this. You want to go ahead and take the break?
If this is a good time to take a break, we'll go ahead and break for lunch at this time. Please remember that admonition, and we'll see you back here at 1:30. Thank you.
Sorry about that. I've been talking to myself. I said I wish they would give it a 30-second or a minute before they start slamming that music on. I don't want to be copyrighted. Okay, y'all, we're going to lunch on their end. Let me see how far into the lunch they are. They're about 18 minutes into the lunch. So we're going to hop on over to this other case. It's been kind of dry today. I get it. It's a part of court. We're going to have some days that are bombing and back and forth and tit for tat. It's going to be great. Then we're going to have days where, oh, it ain't so much. So that's just the way the cookie crumbles. This is very boring. I know to some people in the evidence stacking. I call it evidence stacking. Everybody calls it something different. In my humble opinion, it's evidence stacking. So I saw a job on Indeed where it is an insurance fraud investigator. I think I'd love that. You guys think I'd be good at that? Insurance fraud investigator. And guess what? When you're that kind of a person, you get to go to court and testify. Oh, that'll be brilliant. Hello, Catherine. The volume is very low in court. There's nothing I can do about it. I have gamed it up at Catherine. Catherine Singleton. I am so sorry. I've gained it up. This court is brutally low. Welcome and thank you for joining us. But it is the way it is. There's nothing I can do about it. My apologies. I actually have it gained more than most people do. I do have some give and take on my end on that. Okay, so what we are going to do is we're going to take while they're at break, we're going to go over here to the what used to be the lip filler baby murder trial is now the Brazilian butt lift baby red room trial, where a woman went in to get a Brazilian butt lift, which takes hours, and she left her baby in the car. I'm like, are you kidding me? She left a almost 1 year old, right at 1 year old, and a 2-year-old in the car. The 1 year old did pass away of a heat stroke. We are now including arguments for that trial. Please, for those of you who don't know me, please forgive me. I am still very exhausted. We had a death in the family 2 weeks ago. Last week, and then less than a week after that, I got COVID. And then after that, this past weekend, I had to go out of town, and because I graduated with a degree in criminal justice, so now you guys, I feel like I have more authority in what I say. I feel like I'm a little bit more authoritative. I don't like to speak without authority. So in that, I feel a little bit more confident in myself. But I think it's going to be cool. We'll see what happens with this job. It is so for all those people out there who they think are faking their claims of injury from like workman's comp or whatever, insurance fraud, whatever. I am the one. I mean, I would be an investigator, which I love investigative work. I think that would be so freaking cool, y'all. So I would love to have that job. And you do get a certification. You have to go through training and get a certification. And it's an investigative certification, which would be cool because eventually I think it would be kind of cool to work for the disabilities ADA as an investigator, because that's my specialty, ADA law. And I think it would be awesome to work as an investigator for the ADA. I would freaking love it. That is my like major cup of tea. So I am hoping and looking forward to possibly doing something like that. But I'm starting my job search. So thank you so very, 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 very much. I see you. Oh, we got some breaking news. We got some new information out there, and my ears are kind of giving me hell. Okay. Swiss prosecutors have charged the husband of former Miss Switzerland finalist Christina Josimovic with the red room in the case marked by the staggering brutality. Joksimovic, that's what it is, Joksimovic, I think, an international model mentor, mother of two, was allegedly strangled in her home, then dismembered with a jigsaw and her remains blended, chemically destroyed. Yeah, he made a red drum body remained cocktail. He was literally trying to blend her remains into a liquefied state. Her husband initially told police he found her dead before claiming self-defense, a version investigators say has flatly contradicted by evidence. Law crime Jesse Weber breaks down. Oh, wait. I'm distributing. Okay. This case is in Switzerland, and I am going to reach out again. We have a person on our team who does international investigation for us. I'll reach out to her today and see what information she has, but we will be following that case. So, Maud, you know who you are. If we don't already have it in Discord, please go ahead and open up a file. If we have the file open up already, you are awesome and love you much. I've got to take my morning med. Thank you so much, Catherine. Catherine, are you hard of hearing by any chance? I do provide American Sign Language interpreting when we do have a request for it. Sometimes we have deaf people that do like to hop on, and sometimes all of a sudden I'll change shirts and start signing, and then 10, 15 minutes later I'm done because they were on a lunch break. But we do provide interpreting to the deaf and hard of hearing. Okay, we're going to go into this. I'm going to back it up just a smidge.
Bubbly and engaging in conversations with the other patient.
Now, this is quite loud, so I'll bring it down. But just note that this is the Brazilian butt lift baby red rumor.
She told them that she had two little babies. She told them what her plans were for the 4th of July in a few days. What she didn't tell anybody inside of the waiting room was that her two little babies were actually there. What she didn't tell anybody in the waiting room was that her two little babies were strapped in her car. She testified, oh, I didn't tell them because they're strangers and I don't want to tell them about my life. But ladies and gentlemen, this is where you get to use your common sense. You know better. You know that's not why she withheld that information. She was talking to these people about getting things injected into her butt. She was talking to them about her plans. She was talking to them about the fact that she had children. Oh, but the fact that she had them with her was simply too personal. No, ladies and gentlemen. She knew that it was wrong and that it was criminal, and that if they knew, she would have a problem. That's why she didn't tell anybody her kids were with her in the car. After the defendant's procedure, the defendant left the building and went outside. Shortly after, a few minutes later, the defendant came in carrying Emilio. Emilio, who was completely limp, turning colors, his limbs just hanging. She came in and brought Emilio into the nurse's room. Shortly after that, Miss Murch saw Isabel Carrion come in with Mateo. And Shelby described to you how Mateo looked. He was gasping for air, had bubbles coming from his mouth, had peed through his diaper, sweat through his onesie, was holding an empty bottle. You also heard that he looked like he was going to have a stroke. And that when she touched him and held him, he was hot to the touch. And ladies and gentlemen, these characteristics, these
Coffee time.
observations are of the child that survived. These observations, gasping for air, bubbling mouth, hot to the touch, those are of the child that is okay. Imagine what Emilio was going through. She and Harmony took Mateo into the bathroom where they put water on him, tried to cool him down. They continued their attempts to cool him down when they brought him back out. You actually saw those attempts in the video surveillance where Shelby's holding Mateo and Harmony's patting under his clothes with the wet cloth, trying to cool him down. Then they go and rinse out his dirty milk, rotten milk probably at that time, bottle, and fill it with water for him. And Shelby also told you something that was very telling, ladies and gentlemen. While the defendant was in the waiting room, she was approached and asked by another mother, the mother and grandmother combo sitting on the black couch, to watch their child while she went to the bathroom. And the defendant did. This was over an hour before, and you can see it in the video surveillance, over an hour before the defendant went into her procedure. At that time, she knew people in there were staying. They were waiting for their appointments. They were willing to help each other out. She knew she could have asked one of them, hey, if I bring my kids in here, can you watch them for the few minutes I'm in my procedure? She knew there were options. She chose not to take those options because that would have interfered with her break. At some point, another husband, wife, and another child came into the waiting room. You saw that, ladies and gentlemen. It was the man and the young boy that sat just around the corner from the defendant's chair. You also heard from Ian Blue. He went to the location with Shelby that day. They were friends. You heard from both Ian and Shelby that it was so hot outside. Before they went in, they stopped at the gas station to get ice cream. It was a noticeably hot day. You heard from Ian that throughout the time the defendant was in the waiting room, there were probably about 10 people in total that came and went and were waiting. You also saw that when you watched the video surveillance. You heard from him that the waiting room atmosphere was friendly, engaging, and all the women were talking to each other. This was not an environment, ladies and gentlemen, that is meant to be serene, calm, quiet. That was not this waiting room. This was the waiting room that would have been conducive to kids. This is a waiting room that was conducive to kids. This was a waiting room that had kids in it and that the defendant knew had kids in it. You also heard from Ian, and this was the very important part of his testimony, that at approximately 3 p.m. on that day, he went outside to take his dog to go to the bathroom, Bowser. When he was outside, he was standing by the tree, right by the fence, about 2 to 3 feet from the defendant's car. And he was very clear and unequivocal when he told you, ladies and gentlemen, that that car was not running. There were no signs that that car was running, that any of the systems were running, that there was any air conditioning going on at about 3 p.m. He also told you he had no idea there was anybody inside of the vehicle. There was absolutely nothing to indicate there was anybody inside of the vehicle, and he was unable to see inside due to the dark tint. While Ian was outside, he noticed it was so hot that he had to bring Bowser back inside to get water. Ian recognized that it was too hot outside for his dog to remain outside during the same time of day that the defendant had her kids essentially locked in an inferno with rising heats. Ian thought it was too hot for his dog, but the defendant did not think it was too hot for her babies. Ian was back inside of the business when the defendant left, and shortly after, the defendant came back in with Emilio, followed by Mateo with Miss Carrion after that. And this is where Ian described Mateo as looking like a wet chicken, which is a term that's commonly used in the the Spanish language, according to Mr. Blue. Mr. Blue explained to you that Mateo looked like he was going to have a heat stroke and was gasping for air. These statements, ladies and gentlemen, they might sound redundant. Why did we have to hear the same thing from Shelby that we heard from Ian? And that's because, ladies and gentlemen, these statements show you that they're true. Two different people made the same observations and came in and told you the same thing. That is evidence. That's corroboration that what they saw actually happened. Their testimony is supported by other testimony, other evidence. And while Ian was on the stand, he talked about some of the conversation that was happening inside of the business. He told you, ladies and gentlemen, that when the man and his son came in, there was a statement made that they had to come in because it was simply too hot to wait outside. This statement was made in the same vicinity, in earshot of the defendant. You know this because Mr. Blue specifically told you that he interpreted for the man and he repeated the statement loud enough for everyone in the room to hear. Not only was this statement made, ladies and gentlemen, there was a conversation that followed. A conversation whereby the people in the waiting room started almost joking about the fact, yeah, imagine how hot it is outside with how warm it is in here, and we have some air conditioning. Those conversations, ladies and gentlemen, took place with the defendant while her kids were trapped in the heat. Even those conversations did not make the defendant think, oh, I should probably go check on them. It is pretty hot. She heard the statements, and much like everything else she did that day, she ignored them as they related to her children. She ignored her children. She did not check on them, even though other people came in and were talking about how hot it was outside. Then you heard from Ms. Carrion, Isabel Carrion, Harmony's assistant. She told you that the defendant came in that day for a treatment to her buttocks area. You later learned it's referred to as a liquid BBL, a liquid Brazilian butt lift. Injections into somebody's butt to enhance the appearance. She's the assistant. After the defendant's procedure, she did not pay right away. She said she had to go to her car to get her phone. Some time had passed. Ms. Carrion was concerned that the defendant was going to leave without paying, so she went outside. Her car, her BMW, the white one in the photograph, was parked directly next to the defendant's. When she got to the car, she saw the defendant holding Emilio and moving him upside down. Not on the phone with 911, not giving CPR, not trying to get help, moving Emilio up and down in the car. This action, ladies and gentlemen, came after, from what you heard from Detective McNabb, that the defendant walked towards the business and then back out. Again, that might seem like a small piece of evidence, but think to yourself, she obviously started walking towards the business because she thought perhaps she could get help. And then realized, but then they're all gonna know that I have my kids with me. They're all gonna know that I left my kids in the heat in the car. That's not gonna look bad, or not going to look good, I apologize. So she turns around and walks back to her car. About 2 minutes later is when Miss Carrion comes out, sees her in her car, tells her, you need to go get help. Your baby is not okay. At that point, she goes inside, subsequently comes back out and calls 911 at 4:40 p.m. 6 minutes passed in that time period, ladies and gentlemen. Think about 6 minutes.
Yo, guys, I gotta stop. This is driving me crazy. As a first responder, I just want to freaking bust. What the was she thinking? I swear people treat their puppies better than she's treating her children. You find an unresponsive 1-year-old in your car that you left there, even though you left the AC on. You didn't care to realize that, that shouldn't have done that to begin with. Don't use that you left the AC on as a defense, because the AC does cut off after an hour, which means they were fine for the first hour. It was the second hour plus that they weren't fine. And you sit here and you don't even call 911. You're shaking your child. I understand you're freaking out, but I found my dog dead in my floorboard unexpectedly. She just curled up and died. I didn't realize she had died until I got out of the car and she didn't move. I thought she was just asleep. I was freaking hysterical. I was calling every vet in town. I called the emergency vet. I got people over to help me. I was doing CPR. I was doing CPR on her so fast. It was unbelievable. I did CPR on her for over 30 minutes. We were calling all the vets. We were doing everything to get medical attention for this dog. She was already gone. She had a heart defect that we didn't know about, and she just died. But the point being is, if I'm that frantic over my service dog, can you imagine what I would be over my child? Why on God's green earth are you not? I have no sympathy. You don't leave your children in the vehicle to get a $8,000 to $20,000, depending on where you go, average $8,000 to $10,000 Brazilian freaking butt lift. That money should have gone to the children's care and upbringing, not your ass. Well, I wonder, darling, how does that modified ass feel sitting in jail? Other people will be enjoying it, I'm sure. But this to me is just it enrages me that she did this. It enrages me that we're even here. Why did you just not plead guilty and get this done and over with, boo? By the way, while we're stopped, we have some more. Yes, we have some more. Breaking news. Nick Reiner, the younger son of Rob Reiner and Michelle Singer Reiner, was not medically cleared to appear in court today, according to his attorney. Who is that attorney? Alan Jackson. Hopefully he'll be cleared tomorrow when we can get him here. The attorney, Alan Jackson, said, addressing reporters outside the L.A. courthouse. Jackson would not specifically state what the medical issue preventing Reiner from being cleared, only stating it was procedural. I bet it was maybe in a self-harm state and was not mentally stable to appear. Rob Reiner, 78, legendary actor, filmmaker, and his wife, Michelle Singer Reiner, were found dead in their Los Angeles home area. Excuse me. On Sunday, the couple's bodies were found with stab wounds and close to the family. And sources close to the family told NBC News. They were found in the master bedroom in their Brentwood home. Los Angeles Police Department Associate Chief Dominic Choi said at the department weekly commissions meeting on Thursday, Choi did not give any additional news or insight in their deaths. Rick Reiner has a long history of battle of addiction, which reportedly began when he was a teenager. 2016 interview with The People, he told the magazine he was in and out of rehab for addiction treatments and stated that since this was occurring since the age of 15, Now I have been home for a really long time. I have sort of gotten accumulated back into being in LA and being around my family. The younger Reiner struggles with addiction into heroin and other hard drugs, inspired a 2016 movie, Being Charlie, which he co-wrote with his father directed. The movie focused on a young man who struggles to follow with the advice of a recovery professional. June, maybe we want to watch that movie in Discord? The program works for some people, but it can't work for everyone, Rob Reiner told the LA Times in 2015. When Nick would tell us that he wasn't working for him, we wouldn't listen. We were desperate, and because the people had diplomas on their wall, we listened to them when we should have been listening to our son. On Saturday, Nick Reiner and his parents attended a holiday party hosted by comedian Conan O'Brien, where he was seen being disruptive, according to two people familiar with the situation. The parents were upset and embarrassed about their son's behavior at the party and expressed worry about his health, according to another person. He is alleged to have interrupted the conversation involving comedian Bill Hader when Hader told the filmmaker's son that the conversation was private. The source said that Nick Reiner appeared to pause and stare before storming off. Hader did not return a request for comment. He became a household of Rob Reiner's death has rocked Hollywood. I'm not going to go into his bio. Everybody knows what a wonderful filmmaker. And the former First Lady Michelle Obama stated in an interview with Jimmy Kimmel on Tuesday that she was supposed to see Rob and Michelle Reiner that Sunday night. That's interesting. In a time when there was not a lot of courage going on, they were all kind of people who were ready to put their actions behind what they cared about, she said. And they cared about their family, they cared about the country, and they cared about fairness and equality. Comment by Michelle Obama. Okay, that's where we stand on that. I will probably do a deep dive on this, but thank you very much, June, for that information. Let's get back to court.
And how long 6 minutes truly feels. And you're going to see how long Emilio sat there again without getting the help he needed while his mother, his protector, was trying to figure out how to cover up her actions. You heard from Ms. Carrion that the defendant was not showing any urgency, was not screaming, was not asking for help. Ms. Carrion only knew Mateo was in the back seat because she saw him due to the rolled down passenger side window. The window that was only rolled down after the defendant went back outside. The defendant did not tell her, help my other baby. She just took off with Emilio inside. Isabel saw Mateo in the back seat. She described Mateo as too hot. His skin was red, and flushed all over. He was weak and drenched with sweat. She also described the inside of the car. She initially said that it was hot, very hot. And then she agreed that she had actually told Ian, and I apologize for my language, ladies and gentlemen, but she had told Ian that when she reached her hand in the car to get Mateo, the inside of the car was hot as hell. Compare that statement, ladies and gentlemen, to the defendant's description of inside the car during her interviews with detectives. Compare that, the statement of Ms. Carrion, who has no reason to embellish, no reason to exaggerate, to the defendant who said, it was pretty comfortable. When you know, ladies and gentlemen, that there's no way, shape, or form that vehicle could have been comfortable at that time. Ms. Carrion told you that when she got into the car to get Mateo, the car was not running. The air conditioner was not on. Those also contradict the defendant's statements. And again, ladies and gentlemen, and I will encourage you, when you are considering what statements are credible, what statements to give the most weight to, Take out courtroom 226. Put that on your desk while you're thinking of the witnesses. And ask yourself, well, did Shelby, Ian, Harmony, who we'll get to in a second, Isabel, did they have any reason to lie? Did they have any reason to exaggerate? Did they have any bias or interest in this case? Those are things that are outlined for you in 226, things that you get to consider. And the answer to all those questions is going to be no. These are people who did not know the defendant until that day. They didn't know her before, they don't know her after. They were there for some cosmetic treatment and really ended up in a horrible situation. A horrible situation that is probably going to impact their entire lives. So when you are looking at what these people said and you're comparing it to what the defendant said, then ask yourself, well, did the defendant have reason to lie? Absolutely. Did the defendant have reason to downplay? Absolutely. Did the defendant have a personal interest in how the case is decided? Absolutely. Does the defendant have a bias in this case? Absolutely. You take those two statements, you take the inconsistencies, and when you use those with courtroom 226, you are going to find that you have to believe and give credence and credibility to Harmony, Isabel, Shelby, and Ian long before the defendant. You heard from the nurse, Ms. Pacheco. She explained to you that she is an aesthetic injector. She provides cosmetic procedures to help enhance appearances. These procedures are not medically necessary. Certainly the procedure that the defendant was receiving that day, the liquid Brazilian butt lift, was not medically necessary. These are things to make people feel beautiful. They are elective chosen procedures. She told you that the defendant's procedure took about 15 to 20 minutes. That's consistent with what you saw in the video surveillance. She told you that during the morning hours of June 29th, 2025, she told the defendant that she could bring her kids in. You saw those text messages, ladies and gentlemen. You have them with you in the back if you want to look at them again. That conversation, you know, from both the defendant and from Ms. Pacheco happened before the defendant left Visalia that day. Ms. Pacheco told you that the defendant told her she had to go get her phone from her car because she left it in there because it was dead. The defendant told you that was a lie. That was not what she told Ms. Pacheco. So again, ask yourself, what reason did Harmony have to make that up? Absolutely none. And also look back at her testimony and consider how that testimony came out. She didn't come in here and say, yeah, she said it was dead and that's why she went out and now I know she's lying. She actually couldn't remember right away if that is what the defendant said. She refreshed her memory with the transcript of the statement she gave on the date of the interview. She didn't come in here with any malice. She didn't have an agenda. She was just testifying to you what she saw and what she observed on that day. She saw the defendant then come back in with Emilio. Emilio was limp, purple, and foaming at the mouth. Again, common descriptions throughout, ladies and gentlemen. When she saw Emilio, she told the defendant to call an ambulance because it was clear that he was not okay. And shortly after that, she saw Isabel come inside with Mateo. She said Mateo looked very hot, was hot to the touch, and his heart was beating really fast. This is an important statement, ladies and gentlemen, especially in light of what you heard yesterday from Dr. Thomas Riley. Harmony Pacheco, a registered nurse, told you that she felt Mateo's heart rate and it was beating really fast. Yesterday, Dr. Thomas Riley testified. He testified in the context of Emilio. He was a doctor for Emilio. But he also told you that hyperthermia, one of the things that happens when somebody's body is going through that is their heart begins to beat really fast, essentially until it gives out. So you know that this statement is consistent with what could have been happening. And that Mateo might not have been as bad as Emilio, but he sure was on his way had he not been caught when he was. Based on Mateo's appearance, she took him to the bathroom where she put water on him. She then started putting wet cloths on his body to try to cool him down because he looked like he was going to have a stroke. His bottle, was empty and appeared that it had old milk in it. So she had Isabel rinse it out and put water in it. Again, ladies and gentlemen, you know it was old milk because the defendant testified in court and told detectives that she had left each child with 1 bottle of milk. 1 bottle of milk for 2.5 hours, including the drive from Visalia to Bakersfield. And then text messages, you'll have those in the back with you. They just confirm the conversation. Then you heard from Nurse Gabrielle Long. She was the treating nurse to Emilio. She told you that Emilio's temperature was 107 degrees when he came in on June 29th, 2025. And ladies and gentlemen, I want you to consider something very important when you think about the testimony of Gabrielle Long, Elizabeth Bond, and Dr. Thomas Riley. These are medical professionals who, by their own testimony, see emergencies all day, every day. Not a single one of them had to come in here and reference any documents as to this incident. Not a single one of them had issues remembering Emilio or Mateo from that day. You heard Gabrielle Long tell you that she had never seen a temperature that high in her career. She also told you that Emilio's temperature was likely higher when he was in the car before he had been exposed to the airflow outside, exposed to the air conditioner in the ambulance, and transported into the hospital. Nurse Elizabeth Bond, she provided treatment to Mateo. She came in here and told you that Mateo was fine. He was responsive, he was okay. The one thing she noticed that was interesting to her was that Mateo was very clingy to the hospital staff. And she said, this is weird because most children don't want to be around us. Most children go away from us. He was clingy. He wanted to be held. He wanted to be comforted. And why is that, ladies and gentlemen? Because that day, just before he met Elizabeth Bond, he had been abandoned. He had been abandoned by his protector, by the person that's supposed to protect him. He sought out comfort in strangers because he didn't get that from his mother. She explained to you that the difference between Mateo's temperature and Emilio's, again, can be explained by their age, the body's ability to release sweat, regulate its temperatures as the body gets older. Dr. Thomas Riley, you heard from him yesterday. He's been an emergency room physician for 30 years. You saw how he testified, ladies and gentlemen. When he was talking about Emilio, there were times when he appeared he was going to get emotional. He talked about the lengths they went through to try to save Emilio. That Emilio suffered from cardiac arrest in the field. When he came to the emergency room, he was intubated and they were doing resuscitation efforts. When Emilio arrived, he was pale, ashen, cyanotic, meaning purple or hypoxic, not getting air, no oxygen flow to his body. Emilio was literally lifeless. Is a quote from Dr. Riley. Literally lifeless. He and other ER personnel attempted life-saving measures for at least 40 minutes. When Emilio arrived, his temperature was 107 to 108 degrees. They took steps to cool him down, including ice packs all over his body and a cooling IV. He described these as being as aggressive as they could to try to save Emilio. He told you that a temperature of 107 is not compatible for life. Someone cannot live. A body cannot sustain that temperature. Heart rate fluctuation caused by temperatures cannot sustain life. Dr. Riley explained to you that being exposed to extreme heats for an extended period of time causes the organs in the body to be impacted, causes a chemical breakdown of the cells. And he described to you that when this organ failure is happening, this breakdown of the cells is occurring, that person experiences these things. The person going through this begins to have an overwhelming sense of heat. They may begin to become overwhelmed and hyperventilate, feel like they are suffocating. He said this person can feel like they are being strangled, all from being exposed to the heat. He also told you that Emilio had signs of rigor mortis, stiffening of the muscles in the body as a result of the body shutting down. And that rigor mortis typically begins to set in within 1 to 2 hours. Emilio's organs and his body had already shut down at least 1 to 2 hours before Dr. Riley had ever seen him. Probably the most important sentence you heard from Dr. Riley: early intervention could have saved his life. Early intervention could have saved his life, ladies and gentlemen. And there is one person in this world that could have gotten him the early intervention. One person that knew he was in the car. One person that had a legal duty to him. One person that was obligated to check on him and get him that early intervention. The defendant, by simply going to check on Emilio, could have prevented all of this. But she, again, chose not to. Early intervention could have saved his life. But the defendant did not allow for that to happen. He told you how heartbreaking it was to see Emilio, how gut-wrenching it was when they could not save him. And then you heard about the recreation. Again, kind of like the video surveillance, detectives wanted to ensure they took steps to make this as thorough as possible. And detective told you,
Okay, guys, I got a little worried about my brother from another mother, Joe Schmo, is in the house. And I knew he was supposed to be going out of town. And I know what's going on. He is fine and healthy. Nobody worry. Nobody get concerned. It's more of a logistical thing. So Joe is okay. And I didn't want y'all to be worried about my brother from another mother. So Joe Schmo's okay. But we are talking about the possibility of us going to the Brian Simpson trial in San Antonio. Just down an hour down the road from me, and us going in for the jury selection, opening statements, and closing at least. And then one of us will be in court while I stream, or we'll work it out. But this will be the first time, and I'm working on getting a press pass, a legit press pass, legit, y'all. So anyway, everybody say hello to Joe Schmo.
Detective Barthelmess, well, we don't know what was happening that day. We don't know how
Okay, I need a sound check, mods.
it felt inside the car. Let's try to find out. Let's simulate that day as best as we can. So they looked up temperatures. They found a date that had temperatures almost identical, at times identical, to the date of June 29th, 2025, and that was July 2nd. They got the car. They ran the car for an appropriate amount of time. They took the defendant's car to 31 South Real Road. They parked the car in the same exact parking spot and made sure to arrive in the parking lot at the same time the defendant arrived. And ladies and gentlemen, it's also important to keep in mind that during this recreation, you were informed, you were told they did the recreation in a light most favorable to the defendant. They took her for her word at what she said she did that day. And they did the recreation as such, which meant they stayed in the car for a little while. They used the same times. They used the same parking space. They ultimately got out of the car at about 2:09. shut the doors, locked everything up, and left the car. They left the car with thermometers that had been appropriately calibrated, thermometers that were working, and body-worn cameras to capture the temperatures inside of the car. You also heard that at 4:08 p.m., Detective Jordan's body-worn camera shut off. Could not record anymore. At 4:16 p.m., Detective Barthelmann's camera, which was on Emilio's seat, shut off at 4:16 p.m. Both of those cameras gave the same notice: critical internal temperature. The car got too hot for an electronic device. It was too hot to sustain an electronic device while Emilio and Mateo were still strapped inside of it. You have Exhibit 75, and that is the item that was judicially noticed by the court, that the temperatures in Bakersfield on June 29th, 2025 at 2:54 p.m. was 101 degrees Fahrenheit. At 3:54 p.m., 102 degrees Fahrenheit. And the high temperature that day was 102 degrees. The high temperature that day occurred while Emilio and Mateo were inside of the car. The temperatures in Bakersfield on July 2nd, 2025, the date of the recreation, 2:54 p.m., 101 degrees. Identical to the date of June 29th, 2025. The temperature at 3:54 p.m. on July 2nd, 2025, 101 degrees. 1 degree cooler, actually, than the date of the actual incident. The high on July 2nd, 2025 was 101 degrees. And again, we just went over this, the steps that the detectives took to make the recreation as identical, as similar to the date and issue. Rolled up the windows, shut the door, left the AC running as the defendant described. And that is a setting 4 out of 7 at 60 degrees. With one air vent in the car, ladies and gentlemen, an air vent that the defendant told you was only in the front of the car. Now, I say they did it as the defendant told them because I anticipate, and you have heard, there is statements from the defendant that she left her air conditioner running, that she left her car on. And I urge you, ladies and gentlemen, to accept those statements with caution. Take those statements in light of CalCrim 226. And recognize that although the detectives considered that information in doing the recreation, that is not indicative that they were taking that statement to be true. They were simply conducting the recreation in a light most favorable to the defendant. You do not have any independent evidence that that air conditioner was left on or how it was running at the time. The only evidence you have of any air conditioner came from the defendant, and we'll discuss that in a few minutes. Detective Barthelman specifically told you the questions they wanted to answer with the recreation. Does the engine shut off after an hour as indicated in the owner's manual? The owner's manual that the detectives bothered to look at, but the defendant never did. The defendant specifically told you she never looked at the owner's manual, doesn't even know if she ever had one. That was in her testimony on direct examination. That could have provided her some useful information when she chose to leave her kids in the car, but she didn't care. What was the internal temperature of the vehicle when defendant left Mateo and Emilio inside of the vehicle? If the vehicle does shut off after an hour, how long does it take the internal temperature to rise? What is the maximum temperature inside of the vehicle once the vehicle is shut off? How long were Emilio and Mateo exposed to these temperatures before defendant returned to the vehicle? And guess what, ladies and gentlemen? They got answers to every single question they had. The car did, in fact, shut off after 1 hour, as indicated in the owner's manual. Even with the air conditioner set as described by the defendant, the coolest Emilio's seat ever got was 80 degrees. And that's because by her own statement, if to be believed, she left it on the middle setting with an air vent only in the front seat. The air wasn't circulating to the back seat. Emilio and Mateo were exposed to temperatures of over 100 degrees for over an hour before the defendant returned to the vehicle. Emilio's seat reached ambient temperatures of 116 degrees. And I say ambient temperatures, ladies and gentlemen, because that is the temperature that came off the thermometer that was essentially hovering in the middle of Emilio's seat. But you heard from Detective Chad Ott that the temperature in Emilio's seat as he was sitting in there was likely significantly higher due to his body being in the seat and his body heat going into that area. Temperatures inside the vehicle. Again, ladies and gentlemen, you have this. You'll have it in the back with you. Was testified to, and it is part of the video surveillance. But the car hit 100.5 degrees at 3:25 p.m. By 3:30, had jumped to 103 degrees. By 3:35, had jumped again to 105.2 degrees. By 3:40, had jumped to 107 degrees. By 3:55, jumped to 110.6 degrees. 4:05, 112.4 degrees. 4:15, the last recorded temperature by body cam camera before it died because of the heat, 114 degrees. And the temperature when detectives opened the doors at 4:33 p.m. was 116 degrees. You'll have the photos of the thermometer. You'll have the video of the temperatures rising. You saw it in court. It was boring. Some might even describe that as painful. But you know what, ladies and gentlemen? You got to watch those temperatures rising in the air-conditioned courtroom. Emilio and Mateo experienced that in real time. They experienced those temperatures rising with nowhere to go, nowhere to escape. You got to have the air conditioning, your bottles of water. I believe we even interrupted to take a short break at one point. Consider how painful that was to watch. And Emilio and Mateo had to experience that in real time. You heard from Detective Chad Ott. You heard about his background, his science. He told you about studies he's participated in, studies he's read. Studies he's read in relation to recreations in babies left in hot cars. And he actually told you that he found the results of Detective Barthelmess' recreation to be quite favorable to the defendant. And he said that based upon the studies he read. For example, one study had to do with temperatures, external temperatures outside of 73 to 93 degrees. And the internal temperature of that car rose to 135 degrees, ladies and gentlemen.
Whoa.
Detective Ott told you that the manner in which the recreation was conducted was scientifically sound, that it was done in the way to best achieve the most accurate results. And he even told you that he was quite impressed by the amount of effort that had been placed into recreation. He was impressed by the steps the detectives took and thought about to make this recreation as accurate as possible. And then again, the video surveillance. Ladies and gentlemen, we sat through that video surveillance. About 2 hours in court. There wasn't sound, there wasn't talking. Almost the entire time, we watched the defendant sit in one single chair. Again, it was boring. We might even call parts of it, most of it, or all of it painful. But again, ladies and gentlemen, you experienced those 2.5 hours in the comforts of an air-conditioned courtroom. Emilio and Mateo, they experienced those 2.5 hours trapped inside of a hot car during the hottest time of day. And I say trapped because they had no way to get out. They had no means to get help. They were trapped in an inferno, ladies and gentlemen. So yes, It was painful to sit there for 2 hours, but you had water, you had air conditioning, you had airflow throughout the courtroom. Emilio and Mateo did not get that same courtesy from their mother. And this is just a kind of a combination of the video surveillance with the recreation, where you can see the defendant sitting inside the business, chit-chatting, engaging, laughing, smiling at different times when her vehicle is 105.2 degrees outside, 107 degrees outside, sitting there, legs crossed, arm on her chin, not a care in the world. Her car with her 2 children is 107 degrees.
We have another hour and 20 minutes of this. We're not going to listen to all that. As soon as the Ian Mitcham trial comes back, what we're going to do is I am going to put that back on the slate. Yes. Come on, hearing aids. Function. Thank you. Put that back up and we'll watch that, and then we're just going to piecemeal this through breaks. But y'all, I agree with Miss June. We've got to have limits on these closings, people. She is a good ADA. I appreciate her. I have agreed with a lot of what she said, but I think that you are retrying the entire case again before the jury is not the best way to go. Closings are supposed to be clear and concise and are supposed to just, get it done. It's a wrap up. It's basically to say, this is what we told you was going to happen in our opening. This is what we claimed. This is what we said we were going to show. This is the witnesses we were going to bring. We did A, B, C, and D. We did match everything together. We put the story together as we said. We believe that they did this. You find them guilty because of this. Go through some of the instructions if you need to remind them of their responsibilities briefly. I mean, an hour should be in and out the door. I think anything over than 2 hours, you have totally lost the jury. In my humblest of opinions, I wouldn't be doing it this long. I think she's taken way too long. I really do. I think she's beating a dead horse at this point.
Best case scenario at that time. 108 degrees, still sitting there chatting, not a care in the world. 109.5 degrees, still sitting there, legs crossed, chatting, looking at the other patrons, having a conversation. 110.6 degrees, still sitting in the same chair.
Do y'all not see a child sitting right there? And that's not her child. That is not her child. But why is her child not in there? If you can't take your child with you, you do not leave him in the car. You find a freaking babysitter. If you can pay $8,000 to $10,000 or more for a liquid Brazilian butt lift, then you can freaking afford a babysitter. And if you can't, then don't do it.
Pool, access to the bathroom, water if she needs it, talking to the patrons. 111.5 degrees, bent over, engaging in conversation, sitting in the same chair. 112.4 degrees, still just sitting there, chatting, perhaps talking about their BBLs, their 4th of July plans, while her kids are burning in her car.
Cooking.
113 degrees is when she essentially gets up. She doesn't leave. She's gone from that chair. But at this point, she goes back into the treatment room, down the steps, down a hall, down another hall, still in the business, when her car's getting up to 114 degrees. She starts walking out at 4:33 p.m. She's walking out of the air-conditioned building while her car is the temperature of 116 degrees. And she's walking out not to go check on the kids, but to go get her phone to pay for her treatment. You heard Dr. Glineski testify about the autopsy. He performed the autopsy of Emilio. This autopsy took place on July 5th, 2025. And he explained to you that Emilio had edema, or commonly referred to as swelling of the brain. The brain swelled and it continued to swell and swell until it began to shut down. The shutting down of the brain caused the rest of the organs to begin to shut down. He also told you that somebody going through this edema, swelling of the brain, can feel it within their body. They experience it. This is not a quick death, ladies and gentlemen. This is a slow, painful death where the person begins to feel lethargic. They begin going limp, perhaps unable to speak. They lose the bodily functions. They may urinate, may defecate on themselves because the organs preventing all of that are no longer working. This person might start having seizures and will likely show foamy secretions, all things that were present with Emilio. Dr. Glineski explained to you that the body begins to shut down at 104 degrees. But when Emilio arrived to the hospital at 5:00 p.m., his temperature was 107 degrees, which is probably lower than it was in the car. Emilio's body began shutting down a significant amount of time before he was found by his mother or by the ambulance personnel. Dr. Glineski, in addition to Dr. Riley, told you that it is impossible to survive a temperature of 107 degrees. Dr. Glineski, impossible to survive. Dr. Riley, that temperature is not compatible with life. The cause of death was hyperthermia, commonly referred to as heat stroke. And this is where his testimony got interesting, ladies and gentlemen. He told you that he initially, and he wrote on the death certificate that the manner of death was an accident. But he explained to you why he made that finding. And he said, I hate making findings like this because I have to do it based upon just a little bit of information. Just the information that his investigator provides to him. He told you, I was 50-50 on accident versus homicide. And again, ladies and gentlemen, it's important to recognize and consider these are medical terms. Medically an accident, medically a homicide. This is not a legal term. It is not a legal definition for you to consider. You are the judges of whether or not this was legally murder, legally homicide. These are medical terms. Homicide meaning the death at the hands of another. He told you he didn't have enough information about the defendant's intent or mind state. He didn't have her recorded interviews. He wasn't able to watch those. And he told you that his opinion would likely change were he to find out that she knew it was dangerous and she did it anyway. He was 50-50 before he had information on whether or not the defendant knew the dangers and acted anyway. So he said accident, but he told you that this likely could have been a homicide as well, medically speaking. Now, let's talk about the defendant's interviews, ladies and gentlemen. You will have these interviews with you. You will have them in the back. You can watch them. And as you heard in opening, and as I told you today earlier, and you probably gathered through the course of the evidence, the crux of this case, the crux of your decision is going to be, what did the defendant know and when did she know it? Her interviews, both her first interview on June 29th and her second interview on July 3rd, give you those answers. She admitted to coming to Bakersfield, leaving the kids in the car, had the kids strapped in the car. Those items of evidence, ladies and gentlemen, are uncontested. Nobody's arguing those. Nobody's saying they didn't happen. But one thing she did say in her first interview was she did not know how long she left the children in the car. But you know, after watching the video surveillance and hearing her testimony, that she did know how long they were in the car. She knew how long she was in the business. She was wearing an Apple Watch. Between 2:27 p.m. and 4:08 p.m., she checked her Apple Watch no less than 45 times. She knew how much time was passing. She knew she wasn't just going to be in there for the quick 15 to 20 minutes. She knew that after the first 20 minutes. She knew that after the second 20 minutes. She knew that after an hour passed. And at 3:33, ladies and gentlemen, the nurse specifically told her there was still another person ahead of you. At 3:30, and almost an hour and a half of having been in the business, she knew it was still going to be probably another 40 minutes. And she continued to sit in that chair without any actions. She said in her first interview that she left her phone with her kids because they were watching TV, that she propped it up on the headrest so that they can see it while they were sitting in their chairs with their cookie, their one bottle of milk, and their candies. In her second interview, she tells detectives that she didn't bring the kids inside because they were sleeping and she didn't want to wake them up. So were they watching TV or were they sleeping, ladies and gentlemen? These might seem like small inconsistencies, but it's the inconsistencies that tell you whether or not she is being completely honest. Whether or not she's being completely honest with the detectives and whether or not she was completely honest with you in court. She estimated she was in the waiting room for about an hour. You know that's not true. She knew that wasn't true. She admitted that she did not go to check on the boys at any time. She told you that when she went back to her car, the car was still running. You know from Ian's testimony that that's not accurate. You know from Isabel's testimony that that's not accurate. You know from the recreation that that is physically impossible. Isabel told you that it was hot when she got back to the car. It was not on. The AC was not running. It was hot to the touch. She told you that Amelia was hot to the touch, that Mateo's cheeks were red. That's what alerted her that something was wrong. Those statements, those observations are not consistent with her statement that her car was still running, that her air conditioner was still on. And she says, it sounds stupid for me to say, like, oh, like, I didn't mean for that to happen because, like, I did leave them, but I thought they were going to be okay. It sounds stupid for me to say. Why did she say it that way, ladies and gentlemen? It sounds stupid for me to say I thought they were going to be okay because I know better. It sounds stupid for me to say this because everybody knows better. Then she says that she knew her sister would probably say yes if she asked her to watch Mateo and Emilio, but she didn't want to irritate her. That statement was also different than how she testified on the stand. We'll talk about that in just a moment. Then she testified on the stand that her concern was not that the kids would be running around in the waiting room. Her concern was that they were sleeping. But in this first interview, just hours after the incident, ladies and gentlemen, about 8:25 p.m. on June 29th, 2025, she says, Detective McNabb asks her, so your concern was they'd be running around the waiting room without you? She said, yeah. Your concern is they would be running around, which is why you didn't bring them in? Yeah. But now you know she had a way to prevent that. She had her stroller. She could have buckled them in their stroller. She did not ask about Emilio's condition until 30 to 40 minutes into the interview. Right as the detectives were telling her they were going to take a break, she asks about Emilio's condition. Why did she wait that long to ask? Because she already knew. Because she knew what she did. She knew before she did it, it was dangerous. And at that time, she knew everything had come full circle and the dangers she knew existed actually happened. She said that she knew that leaving the children in the car was a bad decision, acknowledged that her story about the air being on did not make sense when considered with all of the evidence, told Detective McNabb that what she did was irresponsible. She told Detective McNabb that she thought about the fact that it was irresponsible when she got out of the car and left the babies inside.
Okay, guys. We got Houston. We got a problem. Today, day 9 in the Ian Mitcham trial. Testimony and cross-examination continue in the case surrounding the 2015 Red Room Allison Feldman. Proceedings were unexpectedly delayed after the lunch break, but as of the latest coverage, no official explanation has been given as to why the court did not resume. We do not have court. So I'm going to be talking to my mods about what we're going to do today for the rest of the day and where we're going to proceed. In the meantime, we're going to continue hearing the rant. Mods, private chat, please.
Ladies and gentlemen, that she didn't realize it was irresponsible until after the fact. June 29th, 2025, 8:25 p.m., thought about the fact that it was irresponsible when she got out of the car and left the babies inside. That's implied malice murder, ladies and gentlemen. That's an admission to knowing it was dangerous and acting anyway. Detective McNabb, you know, have you heard the radio ads about not leaving your kids in the car? I mean, a lot of cars nowadays, when you get out of the car, they tell you to make sure to check for your kids. Like it's, you know, that's kind of an irresponsible thing to do. Defendant, yeah. Detective McNabb, I mean, do you know that? Defendant, yeah. Detective McNabb, okay. Did you think about that when you were getting out of your car? Ladies and gentlemen, these questions could not be more clear. Did you think about the dangers when you were getting out of your car? Defendant's answer, yeah. So this storyline that you heard yesterday, that she didn't realize it was bad, dangerous, or irresponsible until after the fact, you cannot believe that testimony, ladies and gentlemen. You cannot compare that testimony and her incentives to lie, her reasons to lie, with the...
Okay, guys, I do have to, the landlord has contacted me. I have to go by my sister's apartment and deal with something. Everything's okay, but unfortunately, I now have 2 weeks to get her apartment completely empty and ready for them to re-rent. June is going to take over, and Angela are going to take over the live for about 30 minutes. No big deal. It's basically like my lunch break. And then we're going to let this run. It will go for about another hour and 14 minutes. And then they have an hour lunch break, and then we'll skim through that, and we will decide what to do from that point forward. Hey, Angela, Turtle Mom. I see you saying, hey, y'all. But this is something I have to go deal with right now, so I can't work. It's something legality thing. So I'll return in a few. It should be taking about 30 minutes or less. And then when I get back, we will continue to figure out the rest of our day. Maybe they will restart with a new feed in the Ian Mitcham. I'm going to ask that my mods keep an eye out for that. They may start a new stream. I don't know what happened. This particular trial in court has been real finicky, real odd. I mean, they don't come back in and sit down and say, well, guys, we've had a conflict. We're going to send the jury home today. Nope, they just don't come back. So it can be very frustrating. Oh, lovely. I guess I won't be leaving at the moment. Well, June, can you host this, please? I see the link that you put. I need you to go ahead and put it in your background. Go ahead and pop in, do what you want to do. I'm going to give you the live for the next 30 minutes. This is a news conference coming up with the DA in the LA County Rob Reiner Redrum case. Rob and Michelle Reiner Redrum case. So I do have it in my end, but June, go ahead and pop it up on your end and go ahead and take over the live. We are, if you need to come back to this view, we are sitting at 2 minutes and 14 seconds. I'll put the time here. So, June, I'm going to let this continue. Uh-oh, all of a sudden I'm getting a spinning wheel of death. All right, June has taken over the live. I'm going to pop you up here. I'm going to pop her up. I'm going to bring me down. And I'll see you in a minute. June, you're going to need to turn up your volume, boo. Just make sure it's up. I'll see y'all in a minute. Peace out.
Good afternoon, everybody. This is June, the head mod We are waiting for the news conference to begin with the um, Nick Reiner case. Um, so I will be right back.
June, please enlarge. Whoa, that's loud. Please enlarge the screen. And we might want to fix the ticker. I got a bolt. I'll be right back. Y'all are so amazing. Bye.
To mind or just
There's
in general? Just in general. I knew this was bad in general from hearing people talk about it because everybody knows it's bad. This is information, ladies and gentlemen, that this day and age you cannot avoid. You cannot avoid knowing. Okay, did you think about that as you were getting out of the car? Again, another opportunity for the defendant to say, "Oh, you've been asking me if I thought it was dangerous before I did it? Let's back up, detective. I thought you were just asking me about if I knew it was dangerous now." This is yet another opportunity for her to say, "Oh, I've been misunderstanding you." But she doesn't, because she knew exactly what they were asking about. She says, "I thought it's not like I just left him in there for him to fucking die." That's her statement, ladies and gentlemen. That's from the defendant's mouth when she's being asked about the dangers that she knew. After telling detective multiple times that she knew it was dangerous, that she knew what could happen, that she knew that what could happen to Emilio, him dying, could happen if she took her actions. I want to know your thoughts, or what thoughts crossed your mind. You said it was irresponsible. Defendant, yeah. Detective McNabb. And I don't think anybody, that's cut off, I apologize. And then defendant, but they were sleeping. I didn't want to wake them up either. I didn't want to wake them up either. What does that one word, ladies and gentlemen? I didn't want to wake them up either. I thought about the options. I thought about the potential consequences. But I also didn't want to wake them up. So I let them continue to sleep, if they were sleeping to begin with. But I didn't want to wake them up either. One word, ladies and gentlemen, can tell you almost everything you need to know. She thought about the consequences. She thought about her choices. And she chose the choice that most benefited herself. It was a lot of time in the hot car, and obviously obviously I don't want to beat around the bush here. Obviously, you know damage can happen from that. Defendant, and in the video, she nods her head up and down. Then you have the phone call with Rosendo Gutierrez, the father to Emilio Mateo, that defendant testified about yesterday. You know you did was wrong, don't you? Obviously. Rosendo, huh? Defendant, obviously, I'm not an idiot. She's not an idiot, ladies and gentlemen. You heard Dr. Masako tell you yesterday she's not an idiot. Very average IQ, much like most of us in this courtroom. I'm not an idiot. Of course I knew it was wrong because I'm not an idiot. Only an idiot wouldn't know that you can't leave your kids in the car in the heat. That's what this says. I'm not an idiot. Obviously, I know it was dangerous. Obviously, I knew that. And again, we touched on this earlier. I'm going to go into the defendant's court testimony in just as I discussed with you the statements made by the defendant. As you consider the defendant's testimony while you're in the back, consider Calcrim 226. That is the instruction that the law tells you the factors you can use in evaluating and judging a witness's testimony. And this is important, ladies and gentlemen. When the defendant decides to take the stand, she is to be given the same weight as every other witness. She does not get extra points because she didn't have to testify. She does not get extra points because she is the defendant. Once she takes that oath, she is a witness the same as anybody else. And ladies and gentlemen, you have heard about the presumption of innocence. The defendant is presumed to be innocent. She is not presumed to be honest. She is not presumed to be trustworthy. So when you consider her testimony, consider these factors. Did the witness understand the questions and answer them directly? You heard multiple times during cross-examination where I asked her a question, she answered initially and then added extra to the end. She understood the question, but she wanted to make sure she got her version of the answer out. Was the witness's testimony influenced by a factor such as bias or prejudice, a personal relationship with someone involved in the case, or a personal interest in how the case is decided? Ladies and gentlemen, the defendant, the witness you saw yesterday, the witness Maya Hernandez, is the only witness you heard from in this case that has a personal interest in how this case is decided. She's the only witness that has bias. She's the only witness that has reason to be untruthful. Next, did the witness make a statement in the past that is consistent or inconsistent with her testimony? This kind of goes hand in hand with the factor above. Was she inconsistent in the past? Yes. What does that tell you? That tells you that maybe she's not being honest with you. That tells you that maybe those biases, maybe her interest in how the case is decided is sneaking through from that stand. Those inconsistencies, different statements when she's testifying than what she said to Detective McNabb, those show you that she's not being honest with you, ladies and gentlemen. How reasonable is her testimony when you consider all of the evidence in this case? The thing with her testimony, ladies and gentlemen, is you can consider how unreasonable it is by only considering it against two other pieces of evidence. You can take her testimony in court and simply compare it to her two recorded interviews and know right off the bat exactly how unreasonable it is. But then when you start adding all the other evidence into the case, it blows her testimony out of the water. When you consider everything, including her own prior statements, you're going to see that her in-court testimony was not reasonable. Did other evidence prove or disprove a fact about which the witness testified? Absolutely, including her own statements. So let's talk.
I'm sorry, we need to take a break. It's 10:51. let's take a 15-minute break. We'll have our camera off, and then we'll have the jury step out first, and then the audience. See you in 15 minutes.
Okay, right now, oh, okay, hang on just a second. Angela, you're gonna keep an eye on the background. The newscast is getting ready to come on now.
Appropriately. So if we could have that decorum in here. DA Nathan Hockman. My name is Nathan Hockman. I'm the District Attorney of Los Angeles County. Today I'm here to announce that our office will be filing charges against Nick Reiner, who is accused of killing his parents, actor-director Rob Reiner, and photographer-producer Michelle Singer Reiner. These charges will be 2 counts of first-degree murder with a special circumstance of multiple murders. He also faces a special allegation that he personally used a dangerous and deadly weapon, that being a knife. These charges carry a maximum sentence of life in prison without the possibility of parole or the death penalty. No decision at this point has been made with respect to the death penalty.
Neither am I.
Currently, Nick Reiner is being held without bail. Now, in announcing these charges, I also want to announce that they're just that. They are charges. Charges are not evidence. Evidence is something that we will be presenting in a court of law to meet the standard of proof we meet in every criminal case, which is beyond a reasonable doubt, to 12 jurors who will unanimously have to find that we've met that standard to prove the charges we bring to court. Right now, with respect to the process, once these charges get filed this afternoon, Nick Reiner will be then brought to court. He is going through medical clearance, something that everybody who gets arrested and gets held in a Los Angeles County Sheriff's Department jail goes through. Once he is medically cleared, he will be brought to court to be arraigned on these charges. At that point, he will enter a plea of guilty or not guilty. Now, prosecuting these cases involving family members are some of the most challenging and most heart-wrenching cases that this office faces because of the intimate and often brutal nature of the crimes involved. Rob Reiner was a brilliant actor and director, an iconic force in our entertainment industry for decades. His wife, Michelle Singer Reiner, was an equally iconic photographer and producer. Their loss is beyond tragic, and we will commit ourselves to bringing their murderer to justice. I want to thank LAPD Chief McDonald, who is here today, along with Deputy Chief Alan Hamilton from the LAPD and LAPD Captain Scott Williams and the entire Robbery Homicide Division, who literally has been working around the clock to gather the evidence that have led to the charges we're going to be filing today. Also from my office, I have Assistant District Attorney Maria Ramirez. I have Director of Specialized Prosecutions John McKinney. I have our Head Deputy of Major Crimes Craig Hum. And I have the two prosecutors who will be leading the prosecution in this case, Assistant Head Deputy of Major Crimes Habib Balian and Deputy District Attorney for Major Crimes Jonathan Chung. They will bring their decades of experience to holding this murderer accountable for his actions. At this point, again, you will hear in the media rumors, you will hear speculation, you will hear hearsay. What I'm asking everyone to do is to rely on trusted sources. If it doesn't come from the District Attorney's Office, from LAPD, from the Coroner's Office, or from the courtroom itself, then there's a good chance you are hearing misinformation. Because at the appropriate time, the actual evidence involved in this case will be presented in a court of law. So I ask for your patience until that.
Upon entering the residence, they discovered the bodies of Mr. and Mrs. Reiner. Detectives from our Robbery Homicide Division Homicide Special Section immediately initiated a comprehensive investigation. The evidence gathered led to the arrest of their son, Nick Reiner, who was taken into custody later that night without incident in the Exposition Park section of our city. Today, the Los Angeles County District's Attorney's Office has formally filed charges against Mr. Reiner for the murder of his parents. This case is heartbreaking and deeply personal, not only for the Reiner family and their loved ones, but for our entire city. We extend our deepest condolences to all of those who were affected by this tragedy. I want to take a moment to recognize and thank our criminal justice partners, the District Attorney's Office led by D.A. Hochman, and everyone who worked tirelessly on this investigation. Their swift action, professionalism, and commitment to justice have been instrumental in bringing clarity and accountability to this case. The LAPD remains steadfast in our mission to protect life and uphold justice. We will continue to support the Reiner family and ensure that every step forward is taken with care, dignity, and resolve. Thank you.
We'll now take some questions. Yes, right here in the front. So special circumstances is a situation where one of the enumerated factors that lead to elevating in some ways a first-degree murder case to a special circumstance first-degree murder case occurs. One of those special circumstances is called multiple murders. Here we have two, and it qualifies under the definition of multiple murders to allege the special circumstance in this particular case. I saw over here.
Yeah, he was found with good, solid police work, investigative tools used by Robbery Homicide and Gang and Narcotic Division detectives with the U.S. Marshal Service Task Force involved as well. So we're thankful for the work that was done. I won't go into talking about what was found or anything that could potentially taint the investigation. Yeah. No, thank you again. That's another question I can't touch.
And following up on that, is there any evidence of mental illness in his background?
I'm sorry, please repeat the question.
Is there any evidence of mental illness in his background beyond conviction?
The evidence, any evidence, if there is any, of mental illness for his background will be coming out in the hearings that will occur. We anticipate, again, after the arraignment, the process will go through the normal process a case like this goes through. At the appropriate time, if there is evidence of mental illness, it will be presented in court and in whatever detail the defense seeks to do that. Yes, right here. We don't anticipate any significant delay more than is involved in a first-degree murder case with special circumstances. These are some of the most serious charges that a DA's office can bring against anyone. And we anticipate that the discovery that we will produce to the defense will be robust. It will be very involved. They'll want adequate time to review it. They'll want to go through every single factor that they can ascertain in the defense of Mr. Nick Reiner. So again, this will proceed along the tracks that many of the first-degree murder cases proceed. Do I anticipate it being particularly fast? No, I anticipate it being very thorough. Yes, right here. We are not at this time. Yes. Yes, right here. I'm going to defer to the chief on this.
Hi, I'm Deputy Chief Alan Hamilton, Chief of Detectives. We don't have any specific information we're going to release at this time regarding the family's information they provided. As we move forward, that information will be discussed in the appropriate venue, which will be the court.
Yes, in the front here.
So specifically, he was arrested in a public area, in the Exposition Park area near the University of Southern California campus. He was approached by the officers and he was arrested without incident. There were no indications that he was going to resist or anything like that. He didn't flee or anything like that. He was taken into custody without issue, and he was transported to our police headquarters facility.
Take a question back there, yes. He has been alleged, one of these special allegations is that the murder was committed with a deadly weapon or a knife. As to where and how the weapon was located or will be located, that will actually be evidence we'll present in court.
We got two more questions.
Let me take a question over here. I'll defer to the chief on this one.
I'm sorry, we don't have that kind of specificity yet. We're waiting the coroner to be able to try and determine as best they can at this point, time of death.
We'll take the question back there. Chief, if you do.
Okay, so in terms of how the Los Angeles Police Department became aware, it was a request from the Los Angeles Fire Department, who responded to the scene first. We responded to their request for assistance at the scene of the incident. Our initial West LA officers that responded determined that a crime had occurred, and they immediately notified our robbery homicide division. They've responded, and they've taken over the investigation since that point.
Thank you, everybody.
We'll take one more question. I'll take it right here. So any statements made by the defendant at any point in time would be the type of evidence we will be presenting in court. I'll take one last question right here. Hold on one second. I just identified this gentleman. Sorry. We do not have the estimated time that it will take. We know that they're working on it expeditiously, but as to when they deliver it, we do not have that estimated time. I'll take that one last question back there. these cases, like any of these cases, we will take the thoughts and desires of the family into consideration in making our decision. Thank you all very much.
Okay, there you go. He is being charged with 2 counts of redrum. And if you give me a second. Um, and if you don't remember anything about the O.J. Simpson case, they talked about West L.A. They talked about robbery, homicide. These are the same offices that was involved with the Simpson trial back in the 1990s. So for the people who remembers that trial, there may be some contrast that we can see on if they learned any lessons from that trial on their investigation, and if they kind of got a little bit better. Um, the other thing is if you're not aware of it, Alan Jackson has now been retained. We don't know by whom has been retained to be Nick Reiner's attorney. Now, so most of you will remember Alan Jackson being involved with the Karen Reed trial. He's also the lawyer or the attorney of record for the Brom trial, the Pacific Coast Highway crash, where 4 college people tragically lost their lives. So this is going to be a very interesting case, as Ada has said. We will be following this case as closely as we can, and we will just continue on. Um, so as more breaks, we will be bringing you the breaking news, as you would, you know, as it would be said. Um, but right now, I believe the other court is back from their short break. Let me double check. And guys, I have my volume cranked, so um, I'm doing the best that I can on volume. Uh, just let me know if you can. They also have breaking news out now that Nick Reiner could face the death penalty. So more is coming out, and we'll probably have a lot of updates coming out, you know, quickly. So let's go ahead on to getting set up to start our other trial. Um, Please let me know about the sound. I will do the best that I can. Uh, in lines of trying to crank it up or try to clean it up. Um, so please hang in there. Ada will be back shortly, and we will do the best that we can. And we're also still looking for the see if Mitcham trial will be coming back later today. We still do not know anything on that one. So without further ado, let me make sure that we have that on, that up, and play.
But then you heard on cross-examination that she did in fact.
We're going to resume. Go ahead.
Thank you. Welcome back, ladies and gentlemen. Before we left, we were beginning to speak about the defendant's testimony in courts. And I just want to remind you that CalCrim 226, which will be in your packet of instructions, is going to be very helpful to you in how you decide to evaluate the defendant's testimony in court. So first, we heard from the defendant that she made an appointment for a liquid BBL in Bakersfield for the date of June 29th, 2025. You heard at the beginning of her testimony on her direct examination, she attempted to kind of characterize this as a last-minute type of appointment that she didn't have prior notice of. But then you heard on cross-examination that she did in fact know about this appointment for many days ahead of time, and that she had been working on scheduling this appointment since early May. Plenty of time to make arrangements for her children. Chose not to. She told you during her testimony that she had asked her sister to babysit, and her sister said no. Again, this is another one of those things that might sound fairly insignificant, might be a small point to make, but it shows you that she was not being honest with you. Because you heard in her testimony or her interview, I apologize, with Detective McNabb, that she specifically talked about her sister and the potential of her sister babysitting. And she specifically says, I know if I asked her, she would say yeah, but I mean, like, I know it irritates her. That is not, I asked my sister and she said no. That is, I knew that was an option, but I didn't want to annoy her, so I chose not to take that option. That's evidence of a lie, ladies and gentlemen. You heard that she took both of the boys with her from Visalia to Bakersfield for the appointment, that she knew before she left Visalia that she could bring the boys inside with her. She didn't bring the boys in with her because they were sleeping. Now, this is consistent with her second statement to law enforcement, but it is inconsistent with her first statement as well as her other testimony in court. And that is the fact, ladies and gentlemen, that she left the TV on for them. If they were sleeping and you don't want to wake them, turning on their favorite show, Paw Patrol, probably is not the appropriate route you want to take. The story that they were sleeping does not fit with the other evidence or the actions that the defendant herself said she took. She also said when she testified that one of her concerns was not the fact that the boys might be running around the lobby while she was in getting her appointment. But you saw, and you can see again, if you choose to watch it while you're deliberating, her recorded interview where she does say her concern was that they would be running around. You also now know that there was a solution to that should she have chosen to take it. She told you that she got out of the car about 2 p.m. and went into the business at 4:33 p.m. And it's important, ladies and gentlemen, that you look at these consistencies, and when you look at what she admitted to in court, look at those admissions and compare them to the physical evidence. She admitted, and she was consistent with the things that there was evidence completely showing her to have been doing. This was thought out testimony. Again, she's not an idiot. She's a smart girl. She knew what she was doing, and she knew what her plan was. She knew what her plan of attack was for her testimony. I'll admit to the things that I can't fight. I'll admit to the things that aren't that relevant. But I'm going to deny the issues. I'm going to deny my knowledge. I'm going to tell them I misunderstood. These were planned actions. This was planned testimony. And I think that came off very clearly throughout her testimony. She admitted that she never left to check on the boys. Again, that's going to be very hard to dispute based upon the video surveillance we watched in court. Acknowledged that she was checking her watch throughout her time in the business, and that her watch did in fact display the time when she was looking at it. Left her phone in the car for the boys to watch Paw Patrol, and again, didn't bring the boys in because they were sleeping. This is not consistent with watching Paw Patrol, leaving candies and cookies with the boys. And also, she admitted to leaving the boys with 1 bottle of milk each, no water. She said that she thought the air conditioner would stay on while she was in the business. And ladies and gentlemen, again, I'm going to point out one word that I want you to pay close attention to. Every time you heard the defendant mention leaving the air conditioner on, she used the word, I thought it would stay on. Never once did she say, I knew it would stay on. And that is because she didn't know that, because she had never read the owner's manual. She thought it would stay on, and that thought was wrong. But thinking that the air conditioner would stay on and thinking that that would make her actions okay also tells you that she knew it was wrong and dangerous to leave them in the car in the first place, or else she wouldn't have to reiterate these actions to you. She told you that she did not know if it had stayed on because, again, she never went to check on the boys. She never went to check on the car. She never left the business. She knew she was inside of the business for a long time, And at 3:30, she had confirmation that it would be at least another 20 to 40 minutes before her procedure. So even painting this in the light most favorable to the defendant, at that time, she could have thought, well, I'm not going to miss my appointment, so let me go check on them. But she didn't. Because at no point during that 2.5 hours, during that day, during the Maya day, were her children her priority or her thoughts. She had a stroller with her that she could have strapped the boys in and brought them inside with her. You saw that in defense exhibit number 10. She knew what high temperatures could do to a body. And ladies and gentlemen, not only did she know what high temperatures and high fevers could do to a body, she knew what it could do to her children because she saw it happen to Mateo in the past. More knowledge of the dangers of what her actions could cause that day. She did not tell a single person that her babies were in the car. She told you she didn't tell people because she doesn't tell people her business. Well, ladies and gentlemen, she's chit-chatting for 2.5 hours. If you're really not telling people your business, you're not going to tell them that you're there to get butt injections. If you're really not telling people your business, you're not going to tell them in the first place that you have 2 kids. If you're not telling people your business, you're not going to sit there and talk about your 4th of July plans. If your life is that private that you don't want them to know anything about you, you sit there, you have your hands in your lap, and you are quiet. No need to participate. Or even more so, if your life and your privacy is that important to you, you wait in your car for your appointment. She did not tell people that her kids were with her because she was a private person. She didn't tell people her kids were with her because she knew it was wrong. She knew it was criminal. She knew that could get her in trouble. That is the only reasonable explanation as to why she did not tell the other patrons her kids were with her. It's the only logical explanation that she didn't tell.
That button, it's not liking me. Okay, I got it. Thank you so much, June. You were amazing. Thank you, June and Angela. Y'all are so sweet. Thank you. Picked up one. My son is a manager at Freddy's, and I love the Freddy's steak and cheese. So we're going to be watching. I won't be eating off screen, but I've got this. I've got the live now. Oh, nope, wrong one. Okay. And give a round of applause for my fabulous mods. They did a great job. All right, guys, we are back in trial.
He's dead. I left him in the car, Kayla. I know he's dead. Didn't ask about Emilio for 30 to 40 minutes into the interview. Told detectives that she knew it was irresponsible and dangerous before she did it. Ladies and gentlemen, the evidence that you have has proven to you beyond a reasonable doubt that the elements, not only for implied malice, second-degree murder act committed, but also second-degree murder failure to act. Again, the statements to Detective McNabb tell you what you need to know to bump you from involuntary manslaughter to second-degree murder. She deliberately acted with conscious disregard for human life. It sounds stupid for me to say like, oh, like I didn't mean for that to happen because like I did leave them, but I thought they were going to be okay. It sounds stupid for me to say I thought they were going to be okay. It sounds stupid for me to say that because we all know, everybody knows, Maya Hernandez, know that that's dangerous, and I did it anyway. She knew leaving them was a bad decision. She knew leaving them in the car was dangerous before she got out of the car, and she did it anyway. With the knowledge that her actions were dangerous, with the knowledge that her actions were dangerous to human life, with the knowledge that her actions leaving the kids in the car could result in death, she did it anyway. This is conscious disregard for human life, ladies and gentlemen. Count 3 is 273 AA for Emilio. This is child abuse likely to result in great bodily harm or injury. Requires that the defendant, while having care or custody of a child, willfully caused or permitted the child to be placed in a situation where the child's person or health was endangered. The defendant inflicted pain or suffering on the child or caused or permitted the child to suffer, be injured, or be endangered under circumstances or conditions likely to produce great bodily harm or death. The defendant was criminally negligent when she caused or permitted the child to suffer, be injured, or be endangered. I don't anticipate much argument on this charge, ladies and gentlemen. The defendant admitted to these actions. She admitted to all of these elements. Count 4 is the same charge for Mateo, same elements. An important part to the instruction for this charge for Mateo is that you will see at the bottom of the instruction for 273 AA, I believe it's Calcrim 821, is going to tell you that a child does not need to actually suffer great bodily harm. It's okay that Mateo was okay because the circumstances were likely to cause the great bodily harm.
Look what I found. Let's see if it's still. Nope, never mind. Thought I did. Dag nabbit.
Harm or death. The fact that he was okay does not negate these elements. Ladies and gentlemen, this is going to conclude my argument today. I will have one more chance to get up and respond to the comments that the defense makes for you. That will not be nearly as lengthy as this, I can guarantee you that. But I want to leave you with two things that I left you with in the beginning of the case during my opening
Oh my God.
This case is not about accidents or mistakes. The defendant did not accidentally leave her children in the car. She did not forget they were there. She wasn't thrown for her schedule for the day and missed a stop. The defendant purposefully, willfully, and intentionally left her children in the car. And she did so knowing what could happen. And she did it anyway. This is a case of choices. Choices made by the defendant. Choices that had bad outcomes. Choices that the defendant now needs to be held accountable for. And you, ladies and gentlemen, as the jury, you get to be the ones to hold her accountable for the death of Emilio. And you get to do that by coming back into this courtroom after deliberations and returning a guilty verdict of second-degree murder for the death of Emilio. Thank you for your time and your attention to this matter.
Thank you, Ms. Taccone. Mr. Wakeman, would you like to start at 1:30? I would. Okay, for the jury, we're going to resume at 1:30. Remember, closing arguments aren't evidence. They're important for you to hear what each side has to say. And then obviously it's not time to deliberate, discuss the case, et cetera. We'll see you back at 1:30. We'll be all set up for Mr. Wakeman.
Okay, we're going to take a little break. By the way, I'm already done. I can only eat half of these at a time. Oh, it's so good. And then their tater tots are not normal. They got a good seasoning. They're crisp. They're not soggy. Yum, 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 yum. I know, not healthy. But that's okay. Finally, no rebuttal. Well, we'll see. You know, that's maybe why she took so long. It was because she was not going to rebuttal. I'm just looking at everything. Were y'all talking about the sound? I'm sorry, guys. Unless you have thousands of dollars of equipment, your sound in court this particular court is brutally low. So June did a great job. Yes, Angela, I read it as soon as she posted it. Yep, read it as soon as she posted it. So, yep, we've already done it. Okay, we're going to get into this one. Is that cutting off? Let me see. No. Okay.
And did I'm going to start out by cutting to the chase. There's no implied malice for count one. Maya thought the air conditioning system would stay on. Is there an alternate scenario where you would have a fact pattern similar to this where there would be implied malice? Yeah, there sure could be. If a person in a similar situation would have just walked in to the office or to the spa and did nothing else, then yeah, you could have implied malice in that situation, but that isn't the situation here. So the way that we're going to move through this is I have some preliminary matters that I want to go over with you, very brief. We're going to review the charges. We're going to talk about counts 2, 3, and 4 being conceded. We're going to unpack why there's no implied malice. I'm going to show you why Maya is not guilty of count 1. I'll have a little bit of rebuttal at the end. I worked some of it through over lunch, but there's a little bit that I just didn't get to make a slide for. So we'll finish up with some rebuttal and then I'll have some closing remarks. So, preliminary matters. The jury instructions is the law in this case that's been given to you by the judge. They're called CalCrim and each one has a number. As I move through my presentation, I'll do my best to cite you to those CalCrim numbers. Just as a reference, you'll have them all. If you want to write it down, you can. If you don't, certainly no obligation there. Basically, the jury instructions are self-contained, they're self-guiding. They tell you what to do and they tell you how to do it. The way that I like to look at it is this. Crimes have elements. Each element of a crime has to be proven as required by the jury instruction for that crime. And the way that I like to think about it is this. I compare it to a recipe. Elements for a given crime are like ingredients for a given recipe. Just like you would make a cake, just like you would make a crime. You have the elements, you have the ingredients. Now, there's a key point that I want to start with about the union of act and intent, and it's found in CalCrim, and it's this. The offenses in this case require proof of the union or joint operation of act and wrongful intent. What that means is that you've got to have a guilty act and a guilty mind at the same time, okay? Guilty act and a guilty mind at the same time. If I'm standing here in front of you today and I'm thinking about robbing a bank, I'm thinking about robbing a bank, but I'm not robbing a bank, am I? I'm here in front of you all. So there's no act. I may or may not have a guilty mind, but there's no crime, okay? Works both ways. Guilty act, guilty mind. The reason I bring that to your attention is because when we get to count 1, it becomes important. This idea of the union of act and intent. So let's move into some substance. We're going to begin by reviewing the charges in the case. Count 1 is the second-degree murder for Emilio. That's at 520. That's a felony. Count 2 is the invol for Emilio. That is conceded. Count 3 is child endangerment / death for Emilio. That is also conceded. And count 4 is child endangerment. That is for Mateo, and that is conceded. Now, it was suggested to you that Ms. Hernandez was not taking accountability. On her behalf, I stood up in court in an opening statement, and I conceded 3 felonies. It's hard to get more accountable than that. And I hope that landed, because what I was telling you in open statement and what I'm telling you now is that, yeah, you can find her guilty for 2, 3, and 4. That's what I meant when I was conceding it. That's pretty accountable. So the question then becomes, okay, if this guy's conceding 2, 3, and 4, why talk about it? Why talk about the ones you're conceding? Well, there are 3 reasons, okay? Reason number 1 is because the jury instruction for involuntary manslaughter references the difference between invol and second-degree murder. The second reason is that the child endangerment jury instruction references involuntary manslaughter, and there are mental states that we have to talk about, so they reference each other. But this is really the reason. The reason is I'm reviewing these conceded counts with you and their requisite mental state because I think that it provides insight as to why they fit in this situation and count 1 does not fit in this situation. So let's start to get into a rhythm, okay? These are our ingredients. We're talking about count 2, involuntary manslaughter. The first ingredient is a crime or a lawful act in an unlawful manner. That's the first ingredient. You'll notice the or between crime and lawful. It's in the disjunctive. Both are alleged and both apply here. I'm conceding that count. Second ingredient, committed with criminal negligence. You may notice that criminal negligence is in all caps. I'm trying to draw your attention to it, okay? That's the first mental state. It also happens to be the mental states for 3 and 4, but this is the first time we're seeing it here. I'm conceding it. Third element, cause the death of another person. Yes, for Emilio, okay? All of the elements for this charge are met. This charge is conceded. But we are not done with CalCrim 580. We're not done with it. CalCrim 580 has more to say. In 2 places, 580 defines the difference between second-degree murder and involuntary manslaughter. Second full paragraph and last full paragraph. And 580 defines criminal negligence in 2 different places as well, okay? That would be paragraphs 6 and 8 by my count. If you want to go back there and say it's 7 and 9, there's a lot of little one-liners. It depends upon, I guess, how you do your counting. But that'll get you to the neighborhood, okay? This is also important. There's 3 parts that we're going to go through here. Part 1, criminal negligence involves more than ordinary carelessness, inattention, or mistaken judgment. And then it tells you, a person acts with criminal negligence when 1 and 2. He or she acts in a reckless way, and I'm going to be bringing you back to reckless. He or she acts in a reckless way that creates a high risk of death or GBI, and a reasonable person would have known that acting in that way would create such a risk. Part 2, and this is the jury instruction quote. This is their language, obviously not mine. This is a quote, not a paraphrase. In other words, a person acts with criminal negligence when the way he or she acts is so different from the way that an ordinarily careful person would act in the same situation that his or her act amounts to disregard for human life or indifference to the consequences of that act. Third definition. You've already seen this. This was in Mr. Coney's presentation as well. Obviously, if we're both including it, it's important, right? In order to prove second-degree murder, the people have the burden of proving beyond a reasonable doubt that the defendant acted with conscious disregard. So for all of this, it comes down to those two words. So I would like you to keep the definition of criminal negligence in mind as we keep moving through counts 3 and 4. You'll notice at the bottom there's a little reference. That's for both of us. It keys me to where I need to go, and it kind of lets you know where we're going to. So let's move to count 3. Count 3 is child endangerment for Emilio. Okay? And it has 3 elements, 3 ingredients. First element, the defendant, while having care or custody of a child, willfully caused or permitted the child to be placed in a situation where the child's person or health was endangered. I would ask you to pay particular attention right there to care or custody, because that's going to relate to Maya as a mom, okay? And I'm going to talk to you a little bit about how count 2 and 3 get to the same place factually, maybe, but in a legally different way, okay? Because they have different ingredients. I'm conceding the first element. The first element is met. The second element is the defendant inflicted pain or suffering on the child or caused or permitted the child to suffer, be injured, I missed a comma, or be endangered under circumstances or conditions likely to produce GBI. It's obviously the latter part of that in this case. This element is met. Third element. Look what we have again. Criminally negligent. The defendant was criminally negligent when she caused or permitted the child to suffer, be injured, or endangered. This element is met. This charge is conceded. I didn't run through this again with Mateo. With one difference, these elements apply for Mateo in count 4. I'll summarize that for you in the next slide. The mental state here again is criminal negligence. So if we're summarizing this for 3 and 4, Maya was the mother of both, had care and custody of both, did not check up on them. Proof requirements are met as to both, with the only difference being that count 3 includes Emilio's death, and thankfully counts 3 and 4 are conceded. So here's what I want to bring to your attention. Count 3 and the invol in 2 get to a similar place, but they have a different ingredient, and that is the care, custody, and control. Because otherwise, you could never, if this were a situation where it wasn't your kid and you didn't have care, custody, and control of the kid, you wouldn't be able to get them unless you had the invol. You see what I mean? So different elements apply to different crimes, and different acts and elements differentiate crimes. That's kind of how the law covers things, if that makes sense. So keep in mind that counts 2, 3, and 4 all involve criminal negligence. These are the mental states of the conceded counts. Why is this important? It's important because count 1 is a specific intent crime, and I'll reference 252 and 520 for you. We're switching gears here. The other reason that it's important is because count one requires proof of implied malice. Now, as we start to move into this, we're going to be talking about count one. Excuse me. You're going to see that some of these definitions start to get nested, right? So you'll have 3 ingredients, but then an ingredient will have ingredients of its own, if that makes sense. So dealing with count one now, we're going to use the same methodology as we did before with counts 2, 3, and 4. We're going to review the law. We're going to review the facts. But this is a deeper dive now because count one is not being conceded. Count one is second-degree murder. To prove that the defendant is guilty of this crime, the people must prove, here comes the recipe, 1A, the defendant committed an act that caused the death of another person. We have another disjunctive there with an or. 1B, the defendant had a legal duty to care for Emilio, and the defendant failed to perform that duty. And that failure caused the death of Emilio. Now we get to the and. In between 1B and 2, there's an and. And you'll see that I've highlighted malice aforethought. This one is in the conjunctive. Malice aforethought is required to prove count one. Without it, count one fails for lack of proof. So we're dialing down now on malice aforethought. Let's get the legal definition. And once we do that, we'll talk about why the facts don't support that element in this case. Okay? This is probably my biggest, deepest slide. Okay? Implied malice is defined with 4 elements, 4 ingredients. But what I'm going to do is draw your attention to the fact that it says she, check this out. That's the guts of what matter in this, okay? Element 3, you see where it says at the time? And then you see where it says Maya. For element 3, at the time Maya acted or failed to act, Maya knew her act or failure to act was dangerous to human life. And Maya deliberately acted with conscious disregard. 2 words, conscious disregard. So there's some takeaways. Number 1, second-degree murder is a specific intent crime. We talked about that a moment ago. Takeaway number 2, no conscious disregard, then no second-degree murder. That's what the and is for. That's what that means. So let's talk about some facts. You, as the jury, decide the facts. Facts are based on evidence. Evidence comes from testimony, exhibits, and what the judge tells you to consider as evidence. Pretty straightforward. There are 3 categories of witnesses in this case. These categories are mine, okay? I had to break it up somehow. This is how I chose to break it up. Category number 1 is civilian witnesses. Number 2 is law enforcement. And number 3 is medical witnesses. This is a small universe of facts, okay? I would agree with that. And count 1 is going to turn on how you apply the law, okay? So, civilian witnesses, you heard each one of those people testify. Law enforcement witnesses, there were a lot, so I broke those down into two categories. Again, my categories. I called it foundational and substantive. The foundational people were the people that had to lay well, you can't define a word with a word, but they were the people that had to talk about what they did because other people relied on what they did. Okay, so they had to kind of lay the groundwork for it. And then the substantive. Those were the foundational folks. Those were the substantive law enforcement folks. And then last, I had the medical witnesses. I put medical and not expert. You guys can deal with that. You have all the witnesses. Those are designations. That's just how I grouped it. Okay. I am not going to summarize each witness. There were a lot of foundation witnesses. We just saw that, and that's fine. I'm not going to summarize those folks at all. As we move through this, I'm going to ask you to take a look at and consider facts versus emotions and what really moves the needle, okay? I'm going to address what I think are key areas of testimony, and I'm going to start with the recreation. The recreation as presented, the methodology was flawed, it was outdated, the variables that were present on June the 29th were not accounted for in the recreation, and it was based on a study from 20 years ago. Now, if the idea is that cars in the sun get hot, I believe that. I think that's common knowledge. Cars in the sun get hot. Well, oh, sorry. What I don't think, though, is that the recreation is accurate because it didn't match the conditions that were experienced. The whole purpose of science is repeatability. Otherwise, what are we doing? Now, counts 2, 3, and 4 are conceded in any event. I have some rebuttal points that I would like to make. I think that comparing a child's reaction to heat and a camera's reaction to heat isn't realistic at all. I question why the recreation didn't use a thermometer for the outside air temperature if it was so complete. But again, those temperatures are those temperatures. If the air conditioning worked for law enforcement, a few days later, the AC worked for Maya. And it was asserted that Maya never bothered to read her car's owner's manual. She must be the only one. I don't think she is the only one. I think a lot of people just get in their car and drive it. Now, for the spa witnesses, we had the nurse, the nurse's assistant, and 2 patrons, and I would agree this affected them. It would affect anyone. But none of them can say what was in Maya's mind when she came in. When she was in there, they can absolutely describe her behavior. There's no foul there. But you heard testimony that they thought that she was going to run out. They thought she was going to dine and dash on the BBL. So take that for what you will. If people can read other people's nonverbal cues, it isn't that surprising that someone would be cautious because we all send signals to each other. Some good, some bad, some friendly, some mad, etc. For the medical witnesses, Dr. Riley was the ER doc. Dr. Glenisi testified that there were no abrasions, bruises, lacerations, scars, or burn marks. We had the 2 nurses that testified from the ER. I'll come back to Musako down the road. Just like with the civilians in the spa, the treating medical professionals testified that they were affected. Yeah, they're human. Anyone would be. But when it's suggested to you that Dr. Riley tried everything, well, what else is he going to do? He's not going to come up here and say that he tried 3/4 to save someone. So facts and emotion, what moves the needle? I'm not saying the guy did a bad job at all. What I'm saying is it's okay that he is upset with this. Anyone would be. But when he comes and says, we tried everything, well, yeah, of course you did. I'm glad you did, but of course you did. So let's move to Maya. First interview. There were 2 interviews. They were done by Detectives McNabb and Jordan. Each interview speaks for itself. You have the video. You will have the video. Maya taking accountability doesn't equal conscious disregard. Those are different concepts. Maya thought the AC would stay on. That she said that in the first interview. She didn't know the car would turn off. She left the fob under the seat. She left cookies, bottles, a fruit roll-up, an iPhone for Mateo, and she left them in car seats. That's what she testified to. She also said she never read the manual. She bought it and she started driving it. So again, do with that what you will. You already heard the 911 call, and I hope you'll listen to it again. That call was frantic. Listen to her voice in that call. She tried to ride in the ambulance, and she was not allowed. When the DA crossed Maya, counts 2, 3, and 4 were proven. And I also said, to be fair to the DA, she has to meet her burden of proof, right? That's the law. She has to meet her burden of proof, but we're conceding 2, 3, and 4. My point is, Maya was criminally negligent. That much is clear. Her behavior was absolutely more than ordinary carelessness, inattention, or mistaken judgment. She was reckless in a way that created a high risk of death, or GBI, and a reasonable person would have known that acting in that way would create such a risk. That's why this is involuntary manslaughter and child endangerment. That's exactly why it is. Maya didn't know time of death for Emilio. Maya tried to call CPR. Maya tried CPR on the 911 call with the assistance from the dispatcher. If Maya knew when she Snapchatted her sister that Emilio was dead, why ask McNabb? It's hyperbole. It's what we always engage in, right? Oh my gosh, he's dead, right? Maya asked the guards and they didn't know. Maya's reaction was one of emotional shock per Dr. Musako. I had to do that. I had to call him to get his opinion on that. But is that really surprising? I'm not trying to minimize my own expert, but I don't just get to say stuff. I have to give you a basis. That'd be like the recreation. I have to say, hey, this is an expert. These are the tests that he performed. This is his opinion on this case. The point here is that Maya did everything right as soon as she could. So let's get there. Count 1 is not proven, and here is why. Under 252, the specific intent crime of second-degree murder requires the joint operation of wrongful act and wrongful intent. Under Cal Crim 520, when Maya acted or failed to act, Maya did not have the required state of mind of malice aforethought. Implied malice is the type of malice here, and implied malice requires conscious disregard. That's what's missing in this case. Conscious disregard is missing because Maya thought the air conditioner would stay on. And this is true no matter how you factor in 252. Okay? You have that union of act and intent, right? Act. Let's go back to the definition of implied malice for a moment. At the time Maya acted, Maya knew her act or failure to act was dangerous to human life, and Maya deliberately acted or failed to act with conscious disregard. So we are at the time language here. Scenario number 1. Maya left the AC on and the fob under the seat. She left the cookies, she left the candy, she left them in the car seats, etc. But she left the AC on and the fob under the seat when she went into the office for the procedure. She was conscious of the heat and did the opposite of disregarding. That's why Maya left the AC on in the first place. Now I'm going to back up for one slide because I want to bring to your attention this is what you guys are going to have to talk about. The at the time. Because you're the deciders. And that's why I gave you scenario number 1. That's when Maya left the AC on, fob under the seat, and went into the office for the procedure. Scenario number 2. When Maya was sitting in the lobby, Maya thought the AC in the car was on while she was sitting in there. Should Maya have checked on them? Yes. Parents should check on their kids. What do we call parents who don't check on their kids? We call them negligent. And in this case, criminally negligent. But here's the real distinction for conscious disregard. Okay? This is the distinction for conscious disregard. To really get there. Remember at the beginning I told you about this, the alternate scenario about the person who just walks in and does nothing, right? Okay? This is another one. The prosecution, to really get there, would have to prove that Maya knew the car would time out. See, you're hearing about this hot car, hot car, hot car. Okay? But that's not it. Okay? Hot car, hot car, hot car means that if you're the parent that just walks in and leaves them in a hot car, you're consciously disregarding. That was that alternate scenario, the first one. But this one is hot car, hot car, hot car. Maya knows that it's hot and hot car, so she turns on the AC, thinking it's going to keep running. So in order to get her for conscious disregard, they would have to prove that Maya knew the car would time out and then went in anyway. The point isn't that Maya didn't know that leaving a kid in a hot car is risky. She did. That's why she left the AC on. What she didn't know is that it would turn off. Maya thought she mitigated the risk. And this is true whether she's walking away or sitting in the lobby. For your at the time decision, this is true either way because she thought the AC was on. She was wrong, tragically.
Yeah, thing.
The mental state in count 1 is subjective. I'm not going to burn you all the way back to that slide, but it was the blue Maya. The mental state in the conceded counts 2, 3, and 4 is criminal negligence. And it's guided by the way Those crimes are defined in the instructions. They fit better on these facts. She was reckless. She was reckless to trust the machine. That's it. Do you trust your kid's life to a machine? That's reckless. But yet you do. You trust them to cars. You trust them to baby monitors. You trust your kid with a lot of machines, but you also check on your kid. Okay? Count 1 is a specific intent crime, and the definition of implied malice requires conscious disregard. Conscious disregard has not been proven beyond a reasonable doubt in this case. 2, 3, and 4 have been conceded, but there's no conscious disregard. Therefore, there's no count 1. Reasonable doubt leaves you with an abiding conviction that the charge is true. You have to believe in this case with an abiding conviction that there was conscious disregard. And you can't get there. Maya thought the risk was mitigated. That's really what it is. They would have to prove that she knew that the car would time out. And there's nothing about that in this case. Now I have some rebuttal here, and then I'll go into my closing remarks. My apologies for how I do this. You were told that this case turns on not what did she know and when did she know it. That depends on the count. That depends on the count and the mental state. You were told that she made statements that were not consistent with the car running because the car turns off, and she didn't know that. And finally, it was asserted to you that she didn't tell any of the patrons in the spa about the kids because she knew she couldn't get in trouble. She wasn't in trouble then. And if she was there and she thought that the AC was on, that makes sense. So, accountability is a main purpose of the criminal law. But holding someone accountable means calling an act exactly what it is, not more and not less. This is my final opportunity to speak to you on behalf of Maya Hernandez. Okay, this is it. We'll be done in a minute. Human nature often pushes us into this idea of, well, whoever gets the last word wins, right? Because this is, after all, called argument, isn't it? So I don't get the last word. The DA has the last word, but that's because they also have the burden. They have to prove guilt beyond a reasonable doubt. I'm asking you to find Maya Hernandez not guilty of count 1. Her conduct was clearly criminally negligent. That is what I said to you within the first 2 or 3 sentences the first time I spoke to you. And that's what I'm saying to you now. Her conduct was criminally negligent. But there is no implied malice in this case. And this is definitely not second-degree murder. So, thank you all very much for listening.
Thank you, Mr. Wakeman. Mr. Coney, do you need a minute to get set up?
No, you're on.
Okay, I think microphone will have to switch.
I got you.
Good afternoon, ladies and gentlemen.
No!
As I indicated before lunch, I'm going to keep this brief. This is going to be not only
No! You're done. You're done. You're done. Woo! You're done. You're done. You're done. 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 You're done. 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 You're done. We're done. We're done. Get it to the jury. It won't go to the jury till tomorrow, y'all.
Shorter
Sorry.
than my initial closing argument, but I promise I will keep this shorter than Mr. Wakeman's. First and foremost, ladies and gentlemen, the defendant does not get extra points because her attorney came in here and conceded some counts. She does not get extra points.
Okay, I agree with you, Joe. No. You don't have to know no card's going to time out. You have to continuously be aware that there's so many possibilities of danger with your children if you leave them alone in a vehicle for over an hour. And I agree with him that there's no implied malice, but I do not agree with the consequences. This implied malice is necessary for element for second-degree murder. This is true. However, you know, my grandfather used to say, well, I thought, and he goes, that's what you get for thinking. I thought it was okay to leave him in the car because I had the AC on. I thought it was safe. Well, that's what you get for thinking. Unfortunately, your child paid for it. And, let's listen in.
It's because Mr. Wakeman just got up and said she'll take accountability. She's saying she's guilty of criminal negligence. She's saying counts 2, 3, and 4 had been proved. That does not get extra points. That is not a show of accountability. Perhaps a show of manipulation, but not a show of accountability.
Amen, sister. You preach it. I agree with that 100%. Accountability is, Your Honor, I made a bad decision and it cost me the life of my child. So I plead guilty. I throw myself at the mercy of the court because it was unintentional, stupid decision, unintentional, stupid choice, unintentional, and throw yourselves on the mercy of the court, and whatever sentencing or punishment you get, you take it and you get the hell out. In my humble opinion, taking responsibility is pleading guilty, not wasting all this time and money when it is clear that you left your children in a vehicle. Doesn't matter why or how, but one of them is dead and one of them was severely injured and may have health issues for the rest of their life. You take responsibility. That is accountability. I agreed with this woman. It is not about brownie points, and this is sheer manipulation. 100% agree.
Yesterday, when you heard from the defendant, when she had an opportunity to speak for herself, she didn't take accountability. She gave denials. She told you lies. She does not get to get extra credit or extra points because her attorney is conceding counts on her behalf. It's convenient, though, ladies and gentlemen, if you pay attention, that the 3 counts that are being conceded by the defense are counts that they cannot rebut. They're counts that the defendant herself could not get up here and challenge. And that's because they are counts that rely on the physical evidence you saw in this case. And they're counts that rely on how you would behave and how you would act in a scenario. They're not doing some great deed by conceding counts that they know they cannot contest. So sure, let's challenge the charge that has my mental state at issue, and I'll talk to them about that. We'll get to that a little bit more in a couple minutes. Ladies and gentlemen, you just heard a lot from Mr. Wakeman about not checking on her kids, being criminally negligent, essentially being a bad mom. You heard that she thought the air conditioner would stay on. She thought it would stay on, therefore she's not guilty of murder. But again, what you never heard is she knew it would stay on. And here's the thing, ladies and gentlemen, this is not a scenario where the defendant left the children for 10, 15, 30, even 60 minutes. She left that car for 2.5 hours with no actual knowledge that the air conditioner would stay on. And ladies and gentlemen, this notion of the air conditioner being on and the thought that the air conditioner would stay on while she was in the business is only based upon her statement. That evidence only comes by way of the defendant's statements to law enforcement and the defendant's statements in court. Look at that with caution, because this defendant is somebody who has already showed you that she will take the stand and be dishonest to get herself out of trouble. Everything the defense relies on this case has to do with defendant's statements. Something was very interesting just now from Mr. Wakeman's closing argument. And I said during my initial argument that sometimes what you don't hear can be as important or even more important as what you do hear. Yesterday, we heard from the defendant, and it was all about, I didn't know it was dangerous at the time. I didn't know it was bad at the time. I didn't know it was irresponsible at the time. You didn't hear Mr. Wakeman mention any of that, ladies and gentlemen, because that testimony didn't work out very well for her. You can consider that. Sometimes what is not said can be even more important than what is said. Mr. Wakeman knew he could not get up here in good conscience and argue to you her testimony from yesterday, because even he knows that they are dishonest statements, just like you know that.
Your Honor, I'm going to object in proper argument.
Ladies and gentlemen of the jury, the attorneys are commenting on the evidence, not on each other. Go ahead.
Involuntary manslaughter has been conceded, as you heard from Mr. Wakeman. You also heard the only thing different between involuntary manslaughter and second-degree murder is what the defendant was thinking, what she knew, and her conscious disregard for human life. 2.5 hours without checking on her children who were in a car. Sure, she said she thought the air conditioner would stay on. She never confirmed that. Ladies and gentlemen, had the defendant, Emilio and Mateo's mother, given her children so much thought that day as to go check on them once every 30 minutes, we would not be here today. Had the defendant, the children's mother, given her children enough thought that day to go check on them every 30 minutes, Emilio would still be alive. The fact that she thought the air conditioner was running doesn't matter, because it wasn't, and she didn't know that. And she didn't know that it would continue to run. Mr. Wakeman also argued that count 1 is going to turn on how you apply the law. Ladies and gentlemen, although counts have been exceeded, every single count turns on how you apply the law. And it turns on how you apply the facts to that law. And in this case, when you apply the facts, when you apply everything the defendant did and did not do on June 29th, 2025, when you apply her statements to detectives on June 29th, 2025 and July 3rd, 2025, you apply those facts to the law, elements 3 and 4 of implied malice, you only have one option at the end of the day. And that option is that the defendant committed second-degree murder. Involuntary manslaughter, child endangerment, those fall under that. But the defendant knew what she was doing. She knew before she did it. She knew the dangers, and she acted anyway. Then there was the comment, if the air conditioner worked for law enforcement days later, then it worked for Maya. Nobody has come into this courtroom and challenged whether or not the air conditioning unit worked for one day or not another day. The challenge is, was it on? The challenge is, did she know it would stay on? And she did not. The challenge is, with and without that information, did she know there were risks? With those risks in mind, did she act anyway? And that answer is yes. And we heard some challenges to the recreation and the efforts done by law enforcement. Mr. Wakeman argued that the recreation wasn't done under the same conditions from June 29th, 2025. You know what those missing conditions that Mr. Wakeman was talking about were, ladies and gentlemen? Human beings inside of the vehicle. He's challenging the nature of the recreation because law enforcement did not take children or other humans and put them in the vehicle. He's challenging the recreation because law enforcement did not commit murder that day.
Objection, Your Honor. That's an improper argument.
Argument. Go ahead.
You heard from Detective Bartholomew that he talked to his supervisors. They considered perhaps putting a fetal pig in the vehicle. They were told not to because those conditions were not even fair to a fetal pig, just like they were not fair to humans, just like they were not conducive to human life, which is why Emilio died under those conditions. And then defense argued that you must separate facts from emotion. That's absolutely accurate, ladies and gentlemen, which is why you also have to separate the emotion that you saw from the defendant when she testified yesterday. She does not get extra points for testifying. She does not get extra points for being emotional when she talked about her children. Just as you must separate the emotion of the people's witnesses, you must also do so of the defense witnesses, and that now includes the defendant in this case. I quote, "She did everything right as soon as she could." First of all, no, she didn't. She did not do everything right as soon as she could. Had she done everything right as soon as she could, we're not here today. Had she done everything right as soon as she could, she would have brought the children inside with her. Had she done everything right as soon as she could, she would have at least been checking on her children. The fact that she called 911 6 minutes after she found Emilio, the fact that she did CPR when they guided her, the fact that she allowed him to go to the hospital and wanted to ride with him, that is not doing everything right as soon as she could. That's trying to fix a mess she made. You do not get to shoot somebody in the chest, regret that decision, drive them to the hospital, and then say, well, I'm not guilty. I did everything right as soon as I could.
I object. That's a different mental state.
It's a different mental state. You may continue with your argument about the case.
You do not get to claim because you did everything right as soon as you thought you could that you are not guilty. That is not the standard, ladies and gentlemen. And again, she did not do anything right at any point. She does not get credit for calling 911 when she realized that the danger that she thought could occur actually occurred. And then we have the mitigated risk. Defense argued in their closing argument that Maya mitigated the risk. She mitigated the risk by leaving the key fob in the car and leaving the air conditioner running as she indicated. Ladies and gentlemen, mitigating the risk does not accomplish what the defense thought it was going to accomplish. Mitigating the risk, the defendant taking actions to mitigate a risk, tells you that she knew there were risks to begin with. She knew the risks of leaving the children in the car. She knew the dangers of leaving the children in the car. She showed you that by the attempts she stated she made to mitigate those risks. And knowing those risks, she acted anyway. Knowing those risks, she decided to leave the children in the car. Again, she does not get extra points for mitigating risks that she knew ahead of time and that she acted on anyway. Ladies and gentlemen, everything the defense asked you to rely on today is based upon statements that the defendant made, that she left the air conditioner on, that she left her keys in the car. You must also look at the actual evidence. Look at what she didn't do. She did not check on her children. She did not tell anybody her children were with her. Consider the fact that yesterday you heard a lot of testimony from her about not knowing the risks, misunderstanding the detectives and not knowing they were talking about what she knew beforehand. You didn't hear any of that today. Consider my arguments from this morning where I highlighted the circumstances under which she testified here to not knowing things and when she interviewed with law enforcement officers. Consider all of her actions. Consider what she knew before, what she knew during, and what she knew after. Consider how she behaved inside of that salon while her children were roasting in the car. Ladies and gentlemen, we have heard a lot throughout this trial about the burden of proof. That burden of proof is beyond a reasonable doubt. It is the highest burden in the law. It is a burden that is met every day in criminal courts, and it is a burden that has been met in this courtroom in this trial. It is a burden that has been proven, the charge 1, second-degree murder, has been proven to you beyond a reasonable doubt. I'm going to ask you to go into that deliberation room, consider the facts, consider the law, return the only just verdict in this case, return the only verdict supported by the law and the evidence, return the verdict that is going to hold the defendant accountable for her actions, and that is a verdict of guilty to second-degree murder. Thank you for your time.
Thank you, Mr. Coney. Mr. Wakeman. For the jury, when you go to the jury room, the first thing you should do is to choose a foreperson. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is your duty to talk with one another and to deliberate in the jury room. You should try to agree on a verdict if you can. Each of you must decide the case for yourself, but only after you've discussed the evidence with the other jurors. Do not hesitate to change your mind if you become convinced that you are wrong, but do not change your mind just because other jurors disagree with you. Keep an open mind and openly exchange your thoughts and ideas about this case. Stating your opinions too strongly at the beginning or immediately announcing how you plan to vote may interfere with an open discussion. Treat one another courteously. Your role is to be an impartial judge of the facts, not to act as an advocate for one side or the other. As I told you multiple times during the case, do not talk about the case or about any of the people or any subject involved in the case with anyone, including but not limited to your spouse, significant other, family, friends, spiritual leaders, advisors, or therapists. You as a juror must discuss the case only in the jury room and only when all 12 jurors are present. Do not discuss your deliberations with anyone and do not communicate using anything other than there's some you communicate with that. It's very important that you do not use the internet, the dictionary, or anything else in any way in connection with this case during your deliberations. There were a number of items received into evidence. You're going to get all those back. You don't have to ask for them. So we'll send that all back. We also have the if it's a DVD player, CD player, I kind of get confused, but you get one that will play everything. If you run into any difficulties operating any equipment, just let our bailiff know and he'll help you. If you need to communicate with me while you're deliberating, send a note through the bailiff, either signed by the foreperson or one or more other members of the jury. To have a complete record of the trial, it's important that you do not communicate with me except by a written note. If I have questions, I will talk to the attorneys before I answer, and I will respond to all your questions. It may take a little bit of time for me to talk to the attorneys first. I'll answer all your questions. I'll either bring you here in open court and orally provide an answer, or I'll send a note back with an answer to you. Do not reveal to me or anyone else how the vote stands on the question of guilt or issues in this case Unless I ask you to do so, remember your verdict on each count and any special finding must be unanimous. This means that to return a verdict, all 12 must agree to it. Do not reach a decision by the flip of a coin or by any similar act. And as you know, you're the judges of the facts of the evidence. It's not my role to tell you what your verdict should be. Do not take anything I've said or done during the trial as an indication of what you think I think about the facts, the witnesses, or what your verdict should be. You must reach your verdict without any consideration of punishment. You'll be given the verdict forms as soon as all jurors have agreed on a verdict. The foreperson must date and sign the appropriate verdict form and notify the bailiff. If you are able to reach a unanimous decision on only one or some of the charges, fill in that portion. Only notify the bailiff, return any unsigned verdict form. We're going to swear Deputy Reisenhauer to take charge of the 12. Once you get in there, you're going to make sure you put your cell phones in your blue envelopes that correspond to your seat number. He'll collect the envelopes, as I mentioned, keep them in a box handy for you outside of the jury room. Take your notes with you. Anything else that you brought with you today, take it with you. There's plenty of water back there, so don't worry about that. So let's swear Deputy Reisenhauer.
Do you solemnly swear that you will take charge of the jury and keep them together, that you will not speak to them nor allow anyone else to speak to them upon any subject connected with this case except by order of the court, and when they have agreed upon a verdict, you will return them into court, so help you God?
For our two alternates, just stay for now, okay? We'll have to turn the camera off now.
Yep.
Gait of the person, the build of the person, all of those little details to see whether or not you may recognize him.
And authorities say if you do recognize this person, they want you to call them immediately. Again, they are saying that this is a person of interest, and we're hearing that in this news conference that we've been watching together. Let's pick it up where we left off. The mayor there in Providence.
Okay, we're going to pick up this over here. We have a news conference on Channel 4. Come on. Do what I ask you to do. Cooperate with me, please. Oh, my Lord, y'all.
Defense attorney Alan Jackson, he said the reason for the delay had to do with Nick's condition in custody.
Every single inmate goes through a medical clearance before they can be transported to court. Every one of them. Okay. And that's a process. It's just a procedural issue. And he has not yet been medically cleared. So he will be here hopefully tomorrow.
Right. So as Alan Jackson said there, it appears that the appearance that was set for today will now happen tomorrow. But again, we do expect murder charges to be filed this afternoon. Nick Reiner has been in custody, held with no bail since Sunday night. He's accused of murder by police for the deaths of his parents, director Rob Reiner and his mother, Michelle. The LAPD telling us today both of them were found dead inside the master bedroom of their home in Brentwood on Sunday afternoon. The LAPD tracked Nick Reiner down later that same day, arresting him around 9 p.m. near the USC campus at Exposition and Jefferson. And again, he's been in custody since.
It's just a procedural issue. And he has not yet been medically cleared. So he will be here.
Okay. Here we go. Go. Y'all ready? I'm going to let their commercial run. Okay, so what we're going to do is we're going to run this, and then we're going to sign off for the day. And we'll be back tomorrow for more trial, if there is any. I am not real satisfied, and I find it interesting. I'm not real satisfied, and I find it interesting that the court just cuts things without notifying and telling us why. What is this thing here?
So you want to start
Can I trying to
a business? You might think you need a team of people and fancy tech skills, but you don't. You just need GoDaddy Arrow. I'm Walton Goggins, and as an actor, I'm an expert in looking like I know what I'm doing.
I'm trying to get to this.
Iran promises death to America.
I hate all these dang ads. Hate them. There's a little X right there, but it won't let me X out. 6, 18, 17, 19, 20, 10, 9, 8, 7, 6, 5, 4, 3, 2, 1, 0, and you're done.
County. Today, I'm here to announce that our office will be filing charges against Nick Reiner, who is accused of killing his parents, actor-director Rob Reiner, and photographer-producer Michelle Singer Reiner. These charges will be 2 counts of first-degree murder with a special circumstance of multiple murders. He also faces a special allegation that he personally used a dangerous and deadly weapon, that being a knife. These charges carry a maximum sentence of life in prison without the possibility of parole or the death penalty. No decision at this point has been made with respect to the death penalty. We have requested, and currently Nick Reiner is being held without bail. Now, before in announcing these charges, I also want to announce that they're just that. They are charges. Charges are not evidence. Evidence is something that we will be presenting in a court of law to meet the standard of proof we meet in every criminal case, which is beyond a reasonable doubt.
Okay, so I want to say this. Joe, that's not what I meant, boo. I'm not talking about that. What I'm talking about is I forgot. It has nothing to do with his health. I'm talking about in the Mitcham case, how they go off for lunch and then they just never come back. Or they go for a break and then they just never come back. Or they go on a sidebar or they just never come back. And usually most judges would call the jury back in there and say, okay, jury, we're going to let you go for the day. We've got some things that the lawyers and I need to hash out. Heed my warnings and petitions. Don't do this. Don't do that. Da, 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 da. See you tomorrow morning. We know, and they know, and they know, and we know when that happens that we're not going to have any more court. Instead, they just go on a break or a sidebar or go to lunch and then never come back. It's just like, poof, we're done. So that's what I'm talking about. And it is frustrating and it's a little inconsiderate in my whole opinion. All right. I want to thank my fabulous mods and my brother from another mother and everybody who joined me today. Thank you so much for all your attention and your support. Appreciate you so very much. I am going to go get a nice hot bath. I know it's 5:00 my time. And then I'm going to get in and clean the kitchen and I got things I got to get done. We will be live tomorrow as soon as court is live. We may not be live if court is not live. So until we know otherwise, just go ahead and click the bell, subscribe, y'all. Please, our subscription, for some reason, YouTube took some more. They did. But anyway, go and subscribe. If you have already subscribed, click the bell. If you're not sure, double check. Because some people subscribed a long time ago and then they went back and wait a minute, why am I not subscribed? I did. So go ahead and check that and make sure you do that and click the bell. And then when we go live, we will be, you'll get the notification. Okay. So with that, everybody, have a great evening. Tonight in Texas is going to be a cuddly night, meaning it's just chilly enough. I may actually go sit on my front porch. I have a heater, outdoor heater thing. I used to do that last year. I'll get my blanket, my little iPad and my book and my coffee, and I go and spend about an hour out there getting that nice, good, clean air in my lungs. So everybody have a good night. We'll see you tomorrow, Lord willing. But keep an eye out on our channel. We'll let you know when we go live. All right. See you. Thanks for watching. Please comment, like, share, and most importantly, subscribe. I hope you have an awesome day. Till next time, take care.